To pray.
Let us pray.
Okay, go ahead. Then.
Almighty God, we are gathered here to once again continue the business of the nation and a direction and a path in which we want to go. We ask for your guidance. We ask for your intervention. We ask for your support because there's no way that we could do this without you. These we ask in your merciful name. Amen.
Thank you. Do we have any apologies for absence? Senator Samuda. Welcome, Member Bunton, Member Golding, Senator Horton. We have an apology from absence from Senator Samuda.
Senator Johnson Smith.
And Senator Johnson Smith, who is traveling. Okay. We are now on page 19, section 34FH. I believe for the previous clause, we had asked the Bank of Jamaica to look at precedents for the 6 weeks, whether it could be shorter. You have anything to kind of update us on that, or you're not ready to respond?
We're not quite ready to make a submission, Minister, but we can confirm that there are several precedents for a shorter turnaround time. So we'll be looking at that.
Shorter turnaround time. So we can expect a shorter turnaround time to be proposed by you for the minutes, but you're not ready to settle on a particular date, time.
Not
okay.
Mr. Robinson is going to share those with us.
No, he's saying the indication is that many other central banks produce minutes
in shorter time
period, but they're still deliberating what they think they would like to propose. Let's give them that.
All I ask is the list of those countries could share with us.
Do you have a list of how soon other countries do it that you could share? Can you use your mic, please?
Yes, we have a list. It's a little dated, but it's still useful, and we can circulate.
Can you circulate that?
With your permission.
Okay.
Yeah.
And then when you come with your proposal, you'll give us why you think that would be appropriate for you. Right? Okay. So, and then in part, what's this? 5AB. On Financial Policy Committee, before we begin on that part, there would be comments that would have been made with respect to the Monetary Policy Committee that would apply here, right? Because the structure is similar, even though it's not exact. And as we come upon them, then I would just suggest that we adopt what we had agreed to adopt under the previous part. So you want to start with you want to start,
yes.
General Counsel?
Thank you, Chairman, Minister. So Part 5AB, Sections 34FH to FL, deal with the matter of the establishment and governance of the Financial Policy Committee, which we'll, of course, refer to as the FPC. 34FH deal with definitions, and we have already seen in relation to government company that the recommendation was that this be moved to the general definition section, which I believe was agreed. Committee for this part refers to the FPC. So we could move to 34FI. Under 34FI, this addresses the establishment of the FPC and composition, which is proposed to be made up of 6 members, 4 ex officio and 2 appointed members. And the ex officios, as you see outlined, are the governor, senior deputy governor, senior executive of the bank responsible for financial system stability, and the deputy supervisor. Method of appointment stated as the Governor General in Council. We'd mentioned that the JCCUL and the PSOJ in their comments as regards Section 34F1(2) suggested that the
Just a question. I mean, is it possible that the senior executive responsible for the financial system stability could be the senior deputy governor or the deputy supervisor? And what obtains if that is the case?
That could happen, Chair, as it would right now. I don't know if it's...
And we would just have, in that case, we would just have 3 ex officio members? Would that breach the law? How would that work?
It needs to provide for that eventuality, Chairman.
Yes.
It needs to provide for that eventuality.
Yes.
You know, it should perhaps say, you know, or if that person is a person referred to an A or B, then X, you know, another deputy governor or something else, yeah.
And perhaps this could be as appointed by the board. I think it's the formulation that had been discussed last time around in the other committee.
Yes, correct.
Thank you. So JCCUL and PSOJ.
What would be appointed by the board?
The person, that's the other executive, would be identified by the board. I think the last time around you said shouldn't be by the governor or on the recommendation of the governor, as I recall it.
So the person is not a named person, and there's a space because there's an overlap in functions, and that new person would be appointed by the board.
Yes.
Yeah, okay.
I think that's what had been agreed. So read section 34F1, FI2, the JCCUL and the PSOJ suggested that the FPC should comprise an additional non-executive member to increase the ratio of non-executives to executive members. They suggested that there be 4 ex officio and 3 appointed members. The requirement for an additional non-executive member would not be desirable from the perspective that it is hard enough to find non-executive members to serve the board and various statutory committees who are unconflicted, as we had mentioned in another scenario. In determining the ratio, what is important is to have sufficient numbers of independent members to challenge possible groupthink. The JSDA, in relation to the same section, suggested that the FPC composition, again, they suggest was lopsided. From their perspective, the result was that 2/3 of the committee is made up of the regulator of DTIs with no representation from the non-DTI sector. And they mentioned that the non-DTI sector has a larger asset base, wider variety of licensees. They propose a committee composition that removes BOJ control from the FPC and includes a regulator of non-DTIs to better reflect the construct of the financial system. As such, they recommend a 7-member committee with the following configuration: 2 members from the BOJ, 2 from FSC, 1 member from the Jamaica Stock Exchange, and 2 independents. The role of the we would respond that the role of the FPC is to determine financial policies that govern the conduct and promote the proper functioning of the financial system as they relate from the functions set out at 34 FL, prudential supervision, non-macroprudential policy, remittances and cambio, payments and settlement system, credit reporting, and other financial policy matters. With respect to none of these, would it be appropriate for there to be representation contemplated in the submission? Indeed, representation from the sectors mentioned could present conflicts in the determination of macroprudential policies. We would mention and we would highlight that the FSSC, which is a Financial System Stability Committee, does in fact include FSC, MOF, and JDIC representation, and that committee is responsible for making recommendations on macroprudential policy to the respective regulators, including the Bank of Jamaica. The decision-making for BOJ, just as it would be for the decision-making of the FSC, JDIC, and the Ministry, has to be done by the relevant entities or at each institution. In relation to the Bank of Jamaica, the FPC is that grouping that would play that role. So it is that we do not agree that the suggested change in the composition would be appropriate for the Financial Policy Committee. In relation to 34 FI 5 and 6, FI 5, sorry.
Should we discuss that?
Sure.
Yeah. So, taking BOJ's response to the second of the two suggestions as being supportable. In relation to the first, the rationale for not having a 4-3 split is because it's too hard to find people to make up 3, basically, eligible people.
Yes, we didn't support that. And I think, if I'm not mistaken, this submission had actually mentioned that there was possibly a problem in relation to a casting vote. I don't know if it was here or elsewhere. And the truth is that increasing the membership would not necessarily remove the problem of a casting vote, because there's nothing that says that that all persons will in fact show up. So there was no added value in terms of the numbers if you have a problem with a casting vote. But yes, we were suggesting that the current proposal would be appropriate, which is 4 ex officio, 2 appointed.
I mean,
having an odd number.
A difference of 1 doesn't seem to be in the context of saying that you cannot find sufficient people. But it is true that when we're finished, trying to find the 5 board directors, the 2 MPC, the 2 FPC,
the SC.
That's 9. They what?
The SC
the
as
SC.
well. Yes.
How many on the SC on the supervisory committee?
I think there are 2 others as well.
2 others there. That's 11.
That one? The SC?
Supervisory committee that exists already.
Oh.
Yeah.
So you're talking about finding 12 or so or 13 individuals who don't have conflict, don't have shareholdings, who are properly qualified and so forth. It is going to be a real issue.
People sitting on both. I mean, board members.
Yes, you remember last time we said board members can't,
well,
and we said committees can't.
It says that board members can't.
No, in the last meeting we put an amendment in to say that you can't sit on more than one committee.
Right.
So it is a real practical constraint. There's no doubt about that.
Well, and if there's a equality of votes, the chairman has a casting vote under this scheme.
It does say that, yes. So there's not that issue.
It's not. I don't think it's. The fact is that if one assumes attendance by the members, if there's an odd number, then you won't need to resort to somebody voting twice. So I mean, the idea that having a 7 isn't beneficial because from that perspective, because likelihood is that only 6 will turn up. I mean, I don't know how true or that may sometimes happen, but one would hope that the persons who are appointed attend. Anyway, it's given if you think that is a real issue, Minister, I haven't found that to be the case in the past, but I've not had the issue of the kind of conflicts that arise in this sector.
Yeah. Even to get directors under the current environment is difficult, much less this new environment with far more seats to fill. It is going to be a challenge. So we are on.
Yes, to continue.
On where are you now?
I'm at 4, which has a similar provision to the MPC with the appointment of the FPC members being by the Governor General in Council. In relation to FI 5, this addresses eligibility requirement for FPC members and includes fit and proper criteria and qualification requirements mentioned. Member Golding, in his comments, had pointed to the fact that banking and law were excluded from this particular committee, and we would agree that those could be added and would be of value as well. So we would take that point and propose that that be accepted and supported.
Yeah, sure. I mean, too many lawyers, but
Section
Keep you out of trouble, Minister.
Section 34FI6 sets out persons who are ineligible for appointment to the FBC. This is identical to the provision relating to the MPC. As with the case of the MPC, we propose amendment of A to read appointed members of the board or statutory committees of the bank. Also at E, this would be amended by adding the expression which had been agreed, I think, under the MPC. So if you look at E, 6E, this would be amended to add or a partner or employee of the external auditor of a financial institution. (34FI7) deals with the term.
Yeah, there was a point I had made, which was to do the definition of what a financial institution is.
Yes, I think we had mentioned, Member Golding, that that had already been defined in the general definition section of the Bank of Jamaica Act. So there would be no need to add that here as well.
There's a definition in Part VB, apparently, of that term. Is that now redundant?
At V, what page are you at? The definition I'm speaking about, just by the way, is found in the 10th schedule. So if you look in the 2014 amendment, you will see reference to the financial institution definition. So the point we had made earlier was that that had already been taken care of. So if it had appeared before, it should come out there as well in our estimation.
Right. So I think I had looked at Part VB, which may have been in one of the acts that were passed prior to in the last few years. Where is Part VB found now? Which law inserted it?
Okay, let's look.
Because Section 34G has a definition.
It's the 10th schedule, I think. You see? Yes, but no, you're saying that you're looking for Part VB.
Yeah, I'm just reading what I've written. I don't think I just threw it in there without looking at it. It says the term financial institution used in 6E is not defined for the purposes of the new Part VAA. The definition in Part VB, Section 34G, which refers to Section 34L3, may be used. It says see the 2015 amending Act.
Oh yeah, okay, so that's Act 24 of 2015.
Yeah.
So you could just find that one and you'll see.
Yeah, there's a definition of financial institution there.
That is true, and I think that let me say it is also a duplication.
Yeah.
So we could just keep doing it, or we could probably amend that one as well, but we haven't thought it through sufficiently.
The 10th schedule has now put it into Section 2?
Yes, so if you look at 10th schedule, and I'm going to refer you to, if you follow in page numbers, the very first one, 173. So other members would have this booklet that was given out. And if you look at the one that says
which
the 2014,
I
can't remember the color, but it's 2014.
Yes.
BOJA.
The white tab.
It's white, right. Okay, so
page
173. You have reference to the financial institution having the meaning assigned by the BSA. And when you go to the BSA, it speaks about the financial services. You have the BSA here? Okay, it speaks about, so fellow members, the 2014 amendment defines it to coincide with the definition in the Banking Services Act. The Banking Services Act, which I have before me now, says that the financial institution means a person who undertakes or engages in financial services, and then financial services is defined to mean a long range of matters, including, and I'm just cherry picking, banking, business, lending, consumer credit, pension funds management, financial commercial transactions, and securities.
So why don't we tidy up this now? Because you have 34L with a definition in subsection 3, which
You're talking about VB, Member Golding.
Yeah.
So would I say this, Chair, that I am inclined to agree with you, but I'd ask you to allow us to go away and just to see whether there is any peculiarity about that definition. But I think I had looked and it looked pretty much the same, but I'd like to go back and look at it, Chair, and if it is, then we'll come back and make that proposal.
And if it isn't, I'd really want to know why
And
we
if
need
it
to have
isn't-
two different definitions of financial institution in the same act.
Yes, yes.
Yeah.
I suspect it, but I don't want to commit now. I'd prefer to look at it.
Okay.
Okay.
Okay, so to go into subsection 7, this relates to the term of appointment of the FPC, and the term is stated as 5 years, with members being eligible for reappointment. At 9 and 10, the proposed subsection 9 addresses the revocation of appointment of members of the FPC, being by the GG in council, and the reasons for revocation. As provided by members with regard to the MPC, the provision would be amended to add on the recommendation of the board after Governor General in council may. So members might remember that point. Yes, okay. And then at subsection 9, there's just a typo that we noted, which has E and should be D. Is everybody seen that? And then the third point to mention is that subsection 10 speaks to the publication of the names of the members of the committee in the Gazette and the bank undertaking support functions. So that's as it was, I believe, in relation to the MPC. Meeting frequency, the proposed subsection 11 provides for the committee meeting at such times and days as the committee may determine necessary or expedient. We have a note that Member Golding suggested that there should be a stated minimum number of FPC meetings per year rather than leaving it unspecified, and we think that's a good point, and would in fact suggest that insert that the words not less than 4 times per year be inserted after meet, or some other wording that the OPC might think appropriate, but we would suggest after the words meet, the words not less than 4 times per year. So we do take that point, members. At 34F112, support functions, this proposes that the bank shall from time to time assign such staff, including a secretary assist the committee.
Sorry, just one point I also wanted to add, and this is a general point, sorry, Minister, but the idea of the Governor General and Council revoking appointments and so on, that being the cabinet, is there any other legislation where the cabinet plays a role like that, revoking appointments of public officials and so on? Minister? Yeah. This is the cabinet.
This is Minister of the
Yeah.
Cabinet, yeah.
No, the cabinet. So you can review. Is it subject to judicial
It's just
review?
Sorry. The only thing I would say to member is that I think the philosophy is that he who appoints should be the one to revoke. So hence this formulation. So I think we could bear that in mind as well.
I'm just wondering, if there was a situation where they felt that, the cabinet acted unlawfully in making a revocation decision, took into account irrelevant considerations, or there wasn't due process in the decision to revoke. I mean, you might have a situation where the cabinet is brought before the court, which is a very weird, jurisprudentially very peculiar concept. And just one, ministers have been subject to judicial review forever, in terms of acting ultra vires and all that. So, but for the cabinet to be amenable to that type of judicial process is unusual conceptually. So it just occurred to me when I saw this, Yeah.
In fact, I think there's some precedent. I can't remember if it's some of the constitutional offices like the DPP, where it's actually, I think, a majority of the Parliament for these types of reasons, becomes of unsound mind or fails to satisfy, fails to carry out the functions. If we want to move it away from just the minister, then I don't know if moving it to the cabinet is either to Parliament or to some body independent of the minister, because Governor General and Council, which is cabinet and minister, is very, very similar.
That phrase, Governor General and Council, is not a very commonly used phrase. I remember when it was to do with Hurricane Dean and the decision to defer the election.
There was some confusion about what it meant.
And everyone was scrambling to say, what on earth is this? Until somebody was able to find what that body actually was. I think it's an interpretation that, where is it?
With the appointment of the governor that was done in the 2014 or 2015 amendment, the governor could be removed, and we used a similar formulation, did we not?
It was, if you look in the schedule, let me just double check that as well. I think it's in the schedule. Oh, well, in that case, in the case of the schedule, what we have is schedule, which is, if you look in the Principal Act, the schedule, page 43, the minister may terminate the appointment of any person as governor, senior deputy governor, or director. And then it goes on.
So even the 2014/15 amendment, where the Governor General and Council appointed the governor, that scheme had the minister doing the revocation on advice of the board, or?
No, it was just straightforward, the minister. But in fact, this is a provision that we were seeking to amend later on in the bill, as you will see, where we are providing for this, as we felt this to be an anomaly.
The 10th schedule. Was it the 10th schedule that put in the new provisions relating to the governor?
Yes.
Yeah.
But
and it doesn't deal with revocation?
That did not amend paragraph 5 of the schedule to the Act. It did not.
Okay.
But we were seeking in this bill to address that as an anomaly.
Chairman, you can help me, but my understanding from your opening description of the objectives of these amendments. I'm going back now to when we started meeting at Bank of Jamaica, and part of it was to increase the autonomy or independence of the central bank. But if you still have the minister or the cabinet, which is de facto will be influenced by the minister is part of that. Are you really achieving anything much different from what is here now? Why don't we make it Parliament or a committee of Parliament? It would be more transparent. It would at least force some sort of objective arguments to be put to a parliamentary committee. Maybe, perhaps, if, depending on the sensitivity of the reasons, it could be a committee that meets in camera. So if it was something about an unsound mind or something like that, for the protection of the person, you may not want to do it, publicly. But I think in terms of the general direction that you had outlined in terms of what I was trying to achieve, I think that might be a better solution or a better structure than just having it move from the minister to the cabinet.
Yeah, so Member Golden, the independence that we're trying to seek is independence in the implementation of monetary policy. That is the primary element, and the existing act gives the minister the power to give directions on monetary policy. So the principle, I mean, that's a very powerful clause, and it is the removal of that clause in this bill that is what we refer to when we say we're making the central bank independent. It's independent in the implementation of monetary policy. As we've discussed.
But can somebody who can be removed at any time by the minister really be independent?
No, this is not moved at any time. This is very specific criteria, and here we're talking about the Financial Policy Committee, which is broadening the accountability framework and not accountability framework, broadening, strengthening the governance and diffusing decision making, and under.
But wasn't the decision to change the appointment from a ministerial appointment to something else in the name of further independence? I mean, what was the thinking then?
The thinking was, or is, that we changed the method of appointment of the governor to Governor General in Council back in the 2014-15 amendment, and we're seeking to create a balance of power between the governor and the directors, and so we're elevating their appointment to be of the same significance, the same weight, by having the head of state make the appointment. That's effectively it. So we're equalizing the it's a cabinet, it's a governor general on the advice of the cabinet, and which is what Governor General and Council, my understanding is, means. So that is the intention of making the manner in which we appoint these other members in the governance structure of the central bank equivalent to how we appoint the governor. Not to have the governor appointed in this way and then have them appointed in another way.
And what was the thinking at the time? I mean, when the 2014, was it? The amendment that introduced this at the time, I mean, that was a Ministry of Finance bill, and it was a large bill, and I can't remember the specific thinking behind.
I remember the thing going through the Senate at the time when we discussed that of the Governor General Council, and it was one of the things was it was put forward as the best of all sort of other possibilities in our circumstance. But I was thinking what those sort of things would have come out of the technical. I mean, I know what the Senate thought about it. I was just wondering when it was put into the bill in the first place, whereas the minister used to have that appointment power and it was shifted to the Governor General and Council. What was the thinking behind that? Just to broaden, well, my understanding, and you cannot come in, but my understanding, I wasn't in the administration in 2014, but my understanding was to broaden the decision making. That is not the decision of one person. It has to be a broader decision. So you end up with what some kind of double whatever, the minister and the cabinet, so to speak.
Yeah, so my understanding, I wasn't there either, but my understanding is that it really was moving towards greater independence as well. The supervisory functions were looked at in particular at that time, as members will recall. And even in relation to the formulation that there is now for the board members, it steps it back once removed, because it's no longer the minister alone who would be able to make that appointment, but minister, it would have to be at cabinet's endorsement, and then obviously it would go to the Governor General. I wanted to make one correction to something I'd said, and that is that while the schedule to the Act does in fact say the governor and the other persons mentioned could be terminated by the minister for reasons indicated. In the 2014 amendment at page 176, there was in fact an amendment that spoke to removal of governor. So there is page 176 of that booklet, no, of the 2014 amendment. So you have two provisions then. So 2014 amendment, page 176, speaks to the Governor General in Council may remove the governor from office. So we have that provision, and that's saying the Governor General in Council may. But then in the schedule, we have a provision which talks about the minister being able to terminate for those reasons. I believe in our bill there is an attempt to address that as well. I have to find that, but I think in our bill we are seeking to amend paragraph 5 in order to, at page 30, the word minister and substitute Governor General in Council, and we moved off the persons who weren't appointed by the Governor General in Council. So we're seeking to tidy that up as well. So in summary, Minister, we have a scenario where the Governor General in Council makes that appointment of the board, makes the appointment of the governor, and at the end of the day, we are going to be proposing that the same person who hires would then be able to terminate, which is Governor General in Council for consistency.
Just on reflection, it raises a red flag conceptually for me, because the removal of somebody from an office or post, is a thing which is justiciable if it is not done in accordance with due process of law, or including for a lawfully defensible reason. And so we're bringing the cabinet and the Governor General on the advice, because the Governor General Council is a
yeah,
Governor
but no, remember we've had that before. I mean, I hate to bring it up, but the Governor General is the one who issues the instrument of appointment to senators. I mean, we had a case recently where
but he's just acting on the advice.
Right. So that's what would happen here as well. The Governor General is the one issued. But
the appointer can't remove.
Huh?
The appointer of a senator can't remove a senator. The senator is appointed for his term of office.
No, but the point I'm making though is that in that instant, if somebody felt as if they had need to express grievance, it didn't matter that the Governor General figured in the appointment process.
Well, I don't know what you're referring to. You mean the issue with the letters and all that? I mean, in that instance, the court took a view on whether or not those letters were proper. In not so much because the GG had acted wrongly, but the appointing official, in that case the leader of the opposition, had put in place a mechanism which was considered to be an undue interference with the independence of the senators involved. So the point I was kind of making was that the Constitution, using your example, which I'm not even sure is the best example, but using your example, the appointer cannot remove. The appointer of a senator can't remove a senator. All I'm saying is by using this construct, what you're doing is you're putting the decision maker in the revocation process is the cabinet, or the GG acting on advice on the cabinet, and it gives rise to the possibility of an undesirable situation in which an incumbent is litigating a matter before the court as to whether or not the cabinet or the GG acting on the advice of the cabinet has acted lawfully. And this is not something which I've seen contemplated before in our legal arrangements. And I take the point that it was done in 2014 in relation to the governor, and maybe the point didn't occur to me at the time or anyone else, but I'm seeing it now and we're kind of extending it into other positions of committee members and so on, and thus thinking it's something which I would like the AG's chambers to think about, you know, as to whether they think this is desirable from a separation of powers point of view. And then,
Mr. Chairman, there is a provision in the Constitution, for example, which I think might be analogous, where the Auditor General may be removed from office only for inability to discharge the functions thereof or for misbehavior. In that case, the Constitution provides that the Governor General appoints a tribunal, and it's the tribunal that looks into those matters. Those are not really, you know.
Applies to judges.
Same applies to judges.
And the DPP.
And the DPP. So perhaps this is a model we could look at.
All right, let me just experiment a little bit. You're saying that...
My point is, given the reasons we're talking about, unsound mind, fails to carry the functions, fails to satisfy fit and proper, engages in activities that can be considered to be incompatible. These are things that a sort of tribunal of the court or somebody trained as a judge, I think would be better able to determine,
so
and more objectively determine than a minister or a cabinet.
That's an interesting thought. Let me ask, from the point that Member Golden mentioned earlier, if you had because it has to get to the Governor General somehow, right?
It's referred by the Prime Minister
if it's,
or the Chairman of the Public Service Commission in this case.
Right. So if a tribunal made the recommendation and the Governor General in Council acted on the recommendation, does your...
No, it's not the Governor General in Council, it's the Governor General now. Having established the tribunal, it would be the Governor General Cabinet would be left out of it. It would be that tribunal would report to the Governor General, and then they, whether in this case the Auditor General ought to be removed from office for inability, as aforesaid, or for misbehavior.
And that has been litigated. Those provisions in another island's constitution have gone to the Privy Council. I can't remember, it was Antigua or one of those places. No, St. Kitts. Where is it? Cayman? I thought it was a small name.
The judge in St. Kitts.
For the Auditor General, it was an Auditor General case. I think it came out of St. Yeah.
So if you were to apply that here, a tribunal appointed by who would make a recommendation and the Governor General would act on that recommendation?
But the referral to the Governor General might be from the Prime Minister or the Minister or the Chairman of the Public Service Commission, as the case may be. Yeah.
Who appoints the tribunal?
Governor General.
Regime.
But what I'm saying, the matter would be brought to the Governor General's attention by somebody.
The only thing I would say is that this mechanism is in the Constitution for very high office.
Those are higher offices that are constitutional offices.
The DPP and the judges of the Supreme Court and Court of Appeal.
Yeah.
Now we're talking about a committee within the Bank of Jamaica. As important as it is, it's really a very different.
Yeah.
So whether you're going to use that scheme or the principle of it, which is that to avoid the decision maker being the cabinet, who might be exposing themselves potentially to coming into the arena of a contested situation which goes into the court system. That's kind of that's what bothers me about.
But on that point alone of exposing yourself, if it were the minister, just on that point, exposure, that's okay.
Ministers always exposed,
right,
from any to judicial review.
So is there any way if you had the Governor General on advice of the minister, recommended by a tribunal. Is that what? Not a tribunal. Recommended, not use tribunal. Recommended by a. By the board.
The previous one, when you look at the C in the previous committee, when we spoke about failed to carry out, it included board consultation. So there would have been a bridge before you get to the higher authority. And what you don't want in this situation, in terms of the rule of natural justice, is to expose the Governor General who made the appointment in the first instance to be the one terminating. The termination would have, or the separation would have to come based on a recommendation.
The GG is just a formality. He's not making a decision. He's implementing the decision of somebody else. But once that other person is the cabinet, then you're bringing that.
For the cabinet. All right.
Yeah.
So I think something that we need to think about, but I think it's worthy of thinking about. So if you had a scheme where it's the minister to the Governor General, but the minister is advised by the board on these criteria.
Is there a financial system stability board? There's a committee. I mean, I'm not saying if you could avoid trying to create something new, and some appropriate body of persons could be the ones who make the recommendation on revocation.
I mean, there's there's a supervisory appeals, but that's for supervisory appeals. That wouldn't be appropriate. Why not the board? The board is not. The board won't have committee members on it. So the board is existing, and it's independent of the committee. Well, not really independent, but so if we went with the board recommends or makes a decision and passes it to the minister advises the Governor General.
Chairman, I propose that we ask the technical people and the BOJ to look at a mechanism that would capture the issue of natural justice, the real independence from because Minister, Governor General and Council being cabinet marks of a lack of independence because the politicians are interfering. And also, some point the governor raised the last time, the speed in making the changes. So maybe we need to find a model that captures that. And I don't think we will solve it now, but show it to the technical people, pass it to the technical people to see if they can capture what Member Golden and Bunting and the rest of us have been saying in terms of natural justice and greater independence. Is a fear of the cabinet not just being challenged, but it's just a cabinet involvement in it all. Some of us still remember the latter body year thing, whether that was a single minister or a cabinet decision. It was just a bad decision that so many people feel. So if we can find a model that addresses the issues, then we could come back and address them when a proposal is made.
Okay. So that would take us to 10, subsection 10.
So I think I'd reached
11.
13.
No, you had gone over the page. Yes, that's correct.
I think we're at 13 now. So subsections 13, 14, 15, and 16 are identical to the MPC provisions as relates to chairmanship of the committee for 13, chairman having a casting vote, 14, committee regulating its own proceedings, 15, and the committee keeping minutes and records of its meetings, 16. We just flag that at the item for subsection 14, the JC, CUL, and PSOJ had in their comments noted the provision for a casting vote. This is the one I was mentioning earlier, and the reduction in the need for the size of the committee to be increased, and I think we had discussed that in the earlier provision. If we permit me to move to 17, this provision is identical to the MPC provision as well, And this one relates to remuneration payable to appointed members of the FPC, being as the bank may determine. Members will remember that last time around it was suggested, and I believe agreed, that instead of the bank may determine, one would substitute the minister may determine after consultation with the board. That's what I recall.
Something to that effect.
Yes.
Yeah.
Thank you. And now let's go, Minister and members, to 34FJ and 34FK. The proposed 34FJ speaks to the protection of committee members. 34FK speaks to secrecy requirements of the committee members. Member Golding, in his comments that had been circulated, suggested that at the new section 34FJ, in dealing with the exemption from liability of the FPC members, that section 34E should be applied, of the Bank of Jamaica Act, should be applied as was done for the MPC members. And that had been done at section 34FD on page 16. So for the MPC members, the formulation in 34E of the Bank of Jamaica Act had been applied. And so Member Golding was saying for consistency, the same should apply to the FPC. As member noted, there are two formulations for indemnity. There's a section 34E formulation, which, as I said, was applied to the MPC, and there's a section 34FJ 1 and 2 formulation that applies to the FPC. Now, if you wanted to see 34E, then that would be found in the 2014 amendment at page 208. In the booklet.
Yeah.
Tab, I think the white tab.
The red tab.
It's no red?
This one, because it's in the main act.
Okay, no, it's the white one before that you mentioned. That's the 2014 amendment. You said it was white.
Yeah.
It's still white.
It's still white.
Okay, good.
Hasn't been to the beach.
Okay, so if you wanted to see 34E, which applies to the MPC, that would be where you see it. When you look at 34FJ 1 and 2, which is before you, that is equivalent to Section 8 of the Banking Services Act. And those provisions relate to the supervisory committee. So therefore, it's noted that FJ1 and 2, which is before the committee, is the same as the indemnity applicable to the supervisory committee under Section 8 of the BSA. It is suggested that this is so because the FPC functions resemble closely that of the supervisory committee, having the responsibility relating to licensees. We note that 34E, being applied to the MPC, applies to the bank, supervisor, deputy supervisor, supervisor department, all internal, and the minister, who has functions on the various aspects of the Act, and persons appointed for temporary management. Under 34E, like 34FJ, so I'm really trying to balance and see what the difference is, and it was, something that one had to really tune into. So 34E, like the ones before you, provide for all those persons acting bona fide in the conduct of their responsibilities being protected. What 34J and the Section 8 of the BSA does to me is to add a dimension at subsection 2. So what I'd like you to do is to just look at subsection 2 in 34FJ, and you will see what I'm suggesting is an added dimension. And there it is provided that for these external committee members, the supervisory committee, and now we're suggesting the FPC, where any member of the supervisory committee is exempt from liability by reason only of the provisions of the section, so that means they've acted bona fide, then the bank, it is said, shall be liable to the extent it would be if those supervisory committee were members of staff. This seems to provide an added dimension where members of the public would have this recourse to the bank, even though they may not be able to bring an action against those committee members. This is how I'm seeing the difference between 34E. This is my suggestion, as a difference between 34E and 34FJ. Bearing in mind that the FPC will be carrying out functions similar, then if you were to agree with the formulation in the BSA, then it would seem that for consistency, we would propose, I can see Member Golden ready, you would propose that we don't do we don't do 34.
Quiz team. Huh?
So
press the buzzer.
So Chair, I will just land on this little point that we then would suggest in conclusion that 34E remains the one that we use for the MPC, and 34FJ be the one we use for the FPC as it is for the Supervisory Committee.
I just think this is nuanced in the extreme, and I think that I don't really see the role of the FPC as more akin to what the Supervisory Committee does than to what the MPC does.
No, look at page 23, macroprudential supervision, macroprudential policy. Yeah. So so it'd be, that's definitely more similar to the supervisory function, isn't it?
And I was going to question why that's even there, actually, because if you have a committee that's tasked with that, why are you having that role here as well? But in any event, the supervisory committee, isn't it not dealing with regulated entities, licensees, and there are people, so these are people who you're interfacing with the industry or matters arising from individual participants in the industry. And I can see why, in that instance, even though you want to protect the members of that committee from liability, if an industry participant has been suffered loss as a result of some improper act, they don't lose recourse altogether. They have recourse to the bank itself. In terms of protecting the members of an internal committee of the bank like this FPC, I'm not convinced that there's really any material difference between the MPC members and the FPC members for this purpose. They're not really tackling industry participant issues on a licensee by licensee basis in a way that the supervisory committee is. So when I read it, it just seemed to me really peculiar that we have something as esoteric as an indemnity provision. But
when you look at that, they have to govern the conduct and they need to promote the proper function of the financial system. So that can converge in a single institution. To keep the payment system going and keep the financial system functioning, it may require.
But they're not. I think they're different.
They are definitely different. They're definitely different.
Supervision.
Definitely different to supervision. Yes, but there could be, just citing there could be from this definition instances where the action is not sort of theoretical, kind of applying to the economy in general, but it might converge on action with a particular institution because that institution is somehow acting in a way that is.
I don't think there should be overlap between the functions of the two committees. I think their mandate should be quite clear.
Yeah, but
I don't know if there is that overlap, Member Golin. Yeah. For the FPC, that's on the level of the financial policies. What was lifted from the functions of the SC were two matters to do. I think they're here. The policy matters at B were lifted straight from the BSA. In relation to the FSSC, as I see it, the FSSC is not dealing with financial policies. Senior Deputy Governor, right? So this is quite different from all of the other. This is the entity, this is the body that will be dealing with financial policies. To your point about the difference between the indemnity provisions, several things come to mind. It took a while to digest and to even come to that difference. But the truth is, in terms of what was the thinking behind 2014, The only difference to me seems to be that second limb, which is to do with the ability, I am assuming from the public perspective, to have a direct access to the bank. Now, it could be argued that they would have had that anyway. If you have a statutory committee, the public may well have had it, but for its wisdom, Parliament decided that item 2 would be there, and so we are thinking that it would make sense for the Financial Policy Committee to also resemble the provisions of the SC and the Supervisory Committee.
This is preserving vicarious liability. Essentially, for the committee member, some wrong that the committee member is exempt from liability for.
This is what I was seeing, if you want to try to make a difference.
Yeah.
Now, the truth
if the
is,
bank itself has committed a tort or some other civil wrong, this provision doesn't really change that. That person will have a direct right of action against the bank.
True, and in fact, when you look at 34E, because we said to ourselves that if it is that so under 34FG and the Banking Services Act, the supervisory committee person, the committee member would have been acting bona fide, so they would sue the bank. The person would sue the bank, let us say. Under 34E, it would seem to me that the bank would be protected if the bank were acting bona fide. That in all of the whatever was happening, the bank seemed to me to have protection under 34E, page 208. Because under 34E, it's speaking to no liability incurred by the bank for acts done bona fide. I can't imagine the scenario that happening, but let us say there was a scenario where the bank was deemed to be not acting bona fide, then if there was that scenario, then 34E would not be a protection. I think that's what you were saying earlier.
Yeah, I mean, for me, it really turns on, is this a policy committee or not? I mean, if it's a policy committee, like monetary policy, financial policy, the two things are dealing with different policy areas, but they're both policy committees, and the indemnity provision should be the same. That's my view. The supervisory committee is directly involved in the business activities of economic actors in the private sector, making decisions that may cost them money or postpone their ability to make money or whatever. And that is why I think the provisions may be a little bit different in relation to indemnification. That's my view. You've said that this committee is more like the supervisory committee than it is like the MPC. That surprises me. I see this more as a policy body, which is more akin to the MPC than it is to the supervisory committee.
Yeah,
which is why I was saying conflate or treat this like with like when it comes to something as esoteric as indemnification. I think we spent too long on this already, but I will leave it to you, Chair. I don't feel that strongly about it at the end of the day. But I just think it's a little bit incoherent in the way it's been done.
And I do see your point of view, so I will leave it to the committee. I can see that point of view as well. If it is a financial policy committee.
In the last sort of line of 34 FLA, where it describes what the committee does, it says, well, including policy matters relating to 1 to 5, right? The financial, on all issues, and for decisions on all issues relating to financial policy, including policy matters relating to. Yeah, I think the point is that it is a policy committee.
Yes, it is.
Huh?
It is. And I mean, I do see the point of view. So it is. And it could be, too, that even if there were such matters, the public could in any event sue the bank, I'm thinking, if it's a committee of the bank. So I also...
Yeah, so let's take it out. Let's treat it as a policy committee.
Yeah.
We could just simply replicate what was on
for the monetary
16.
policy committee. Yeah.
For MPC, yes.
Yeah, which is 34 F.
Okay,
D, I think. Yeah.
I believe we're at 34 FL, functions of the FPC. FL addresses the proposed functions, which includes being responsible for determining financial policies, and I think we went over this already. So I would
Council,
just
could you
mention
just refer
that.
us to where the supervisory committee is established? Which of these bills did it or acts did it?
Supervisory committees in the BSA, and I believe it's section 6 of the BSA.
Would that be in our booklet here?
No, sorry.
No.
You don't remember it? I mean, you did it a couple of years ago.
That was a weekend, couple of weekends work.
But I'm trying to, you haven't, no, he needs a copy.
Couple of weekends work. I can't remember if any of the people in this room were in that room with me, but.
If I find an extra copy here, I'll.
No, I just want to see, because.
Oh, I?
Functions are
What you looking for?
section 7. Functions
The functions are at 7. Is that what you're looking for?
The functions of that committee and how they compare with these is really what I'm interested in.
Okay, so just to give an idea,
Yeah.
the functions are at section 7 of the BSA. Let me just get that quickly. So just to go back a quick bit, the supervisory committee is constituted under section 6. 7, they consider and make determinations of the following. So they do matters like grant refusal of licenses, you know that, determine whether a person is fit and proper, matters relating to establishment of branch operations and corporate group restructurings, mergers, acquisition, that sort of thing, exemptions from statutory exposure limits, variation of prudential capital adequacy requirements, authorization of arrangements for sharing of information with other regulators, etc., etc. The 2 that were moved are the ones I mentioned, which is H, I think, and M, which now talking about standards of sound practices, which is more going into regulations and regulations and codes of conduct and stuff like that.
Those have been moved into B here?
Those 2 were moved into B,
yeah.
but the supervisory committee continue to function in the way it does. So they actually, that committee actually makes the decision in relation to licensees. So from that perspective, you are right that that committee is a little different from the FPC, if that's where you're going.
In F34 FLA, for example, Roman 1, this is to do with policy around prudential supervision.
Yes,
Yeah, supervisory
correct.
policy and. Yeah,
Yes.
I see. Okay. Right. Okay.
Okay. Just to mention that we pulled off that the JCCUL queried whether the FPC would be making supervisory rules for the credit unions falling under the proposed Credit Union Special Provisions Act, and we'd respond that the FPC might have this responsibility, but the provisions for the credit unions are to be addressed by Parliament when the bill is presented, but if it is, then it's likely that that would come under the FPC when the time comes. That would take care of the FPC, Minister Chair, and I'll hand over to
For
Senior
section
Deputy
16,
Governor.
who's going to do that? Senior Deputy Governor?
Yes,
Deputy
I'll
Senior-
take that. So section 16 of the clause of the bill has to do with emergency liquidity assistance and the collateral policy around that. So there are 2 proposals here. The first is to amend section 34M B of the Act by including the words notwithstanding section 23F. And this seeks to make it clear that loans to FIs, financial institutions, to promote stability in the financial system are not subject to the restrictions of section 23F, which addresses temporary advances to financial institutions, that is under 6 months. So it separates, it distinguishes the extension of credit for financial stability purposes from the normal advances to financial institutions. And clause 16B of the bill seeks to amend section 34MD of the Act, which presently provides that the bank may, in providing emergency liquidity assistance, require and accept collateral on such terms as the bank may determine. And then the proposed new section, 34M, D.
Sorry, Mr. Robinson, 34M, and maybe Council can assist. Where is that found?
2015 amendment.
2015 amendment.
And in particular, page 12.
And we amended it further here.
Yeah.
Yes,
yes.
being amended here.
We amended it further to take out the 75%.
Right. That is the...
Correct.
Yeah.
So if you're looking for the current, you're looking at page 12 of the 2015 amendment in the booklets.
Yeah.
Right. So this proposal, section 34MD, limits the bank from providing emergency assistance unless, one, the financial institution has demonstrated that it failed to gain access to loans from the financial markets, and in the opinion of the bank is unlikely to do so. The financial institutions will be charged an interest rate on the loan to be determined by the bank, and 3, any discount to be applied by the bank on the collateral provided shall take into account the bank's determination of the risk of the collateral being provided. And 4, remedial measures agreed by the bank are adopted by the board of the borough. And 5, the financial institution is solvent. We had received a query as to what is meant by the undefined term solvent. And Member Golding suggested that in a liquidity crisis, the solvency may be threatened by the absence of liquidity itself. So that for the purposes of this section, it was suggested that solvent be defined as the financial institution's assets exceeding its liabilities, which we think is a foolproof
Mr. Chairman.
definition.
Right, so you'll be willing,
Yes.
you're accepting that. So
We would. We would suggest.
go ahead, Member Bunting.
One of the concerns I have with this section is that when a financial institution needs emergency liquidity assistance, it needs it fast. I mean, by definition, right? It's self-evident that if it needs emergency liquidity assistance, it needs it now. Now, you are putting here a burden on that financial institution to prove that it has failed to access loans from the financial market, that it is solvent, etc.
It's likely to fail.
Sorry?
It does say failed or likely to fail. So, I mean...
Yes, but I mean, you're in the middle of a liquidity crisis. You come and say, look, I have these securities on my books, which I will offer you.
Just remember, you're on two sides. I mean, you're on the people you represent in Parliament. This is their institution. So we want to make sure that when the central bank advances money, right, it's doing so because there is genuine need, right?
He's talking on behalf of the system and the stability of the system.
Yeah, I represent all people. I represent all people, not one side or the other. I'm representing all. I'm seeing my role here as doing what is systemically best for the country. Now, I'm saying, as perhaps one of the few people who has managed an institution through a private institution, through a liquidity crisis, I know that when you go and bureaucrats start building obstacles, prove this, prove that, prove this, prove that, liquidity an emergency liquidity situation can quickly become an insolvency.
And the public purse
Yes, and then the bailout for that at the end of the day can be much more. So I would much prefer, well, first of all, usually the interest rates that will be charged to access this emergent liquidity situation will by themselves be a deterrent to using it as a routine form of financing or accessing liquidity. So that by itself means that the institution won't come to access it if it has alternatives, because it's very expensive to access it. So therefore, to put all these other hurdles, well, you haven't proved to me. Go and get a letter from every commercial bank and every other financial institution to say they've denied you accessing loans. Go and, get Pricewaterhouse or some big 8 firm to give us an assessment that you are solvent.
But let's go.
When all of this is happening in real time, dynamic, and just a very delay in accessing could precipitate insolvency. This is worded by a bureaucrat with no practical experience of navigating a liquidity crisis.
Okay, totally understand your point, but let me ask you something. You agree, however, that the central bank has no role lending into a liquidity crisis if the financial institution can easily access from somewhere else?
Correct. But if it could easily access, why would it be coming to the central bank?
Well, let's just start where we agree. So we agree that if it can access it somewhere else, then it has no business getting it from the bank. So we need to have something in there that doesn't. You're suggesting that the punitive measure of the interest rates should be the only check as to whether or not the private institution has other alternatives. Because if they had other alternatives, they wouldn't agree to pay the high price.
But the whole thing is discretionary anyway, Minister. In other words, it's not like I can go and say, give me the money.
Sure. The bank still has discretion.
I'm coming saying, this is happening in my institution. I'm in overdraft with my commercial bank.
Yeah.
Or I'm on overdraft with BOJ. They will know at that point, wouldn't they? I mean,
The word demonstrate is probably what is irritating you, Memo Golding. I mean, demonstrate sounds like a high, not Golding, Mendo Bunting, sorry. It sounds like a high level, a high bar.
I have to come with evidence now, So as I said, what is this evidence? Get a letter from every commercial bank or possible lender saying that they've turned you down.
Demonstrate sounds high. Yeah. I understand what you're saying. Senior Deputy Governor?
We're seeking to set some ground rules on access to credit, particularly by institutions who we don't supervise.
You see, as a practical matter, Mr. Robinson, the institution would probably come and say, look, here are some government securities that I have. Repo them for me at a particular rate. The Bank of Jamaica would not be exposed to credit risk on those instruments because they're government securities. It could be executed quickly. These things are dematerialized now. It's payment against delivery. And it is the discount rate or the rate that you apply on the repurchase agreement for whatever period that will ensure that it's not going to be used as as anything but a last resort. Of course, it must be not so punitive that it precipitates the insolvency. So a balance has to be found. But the Bank of Jamaica would always be aware of the rates in the market and what would be a rate that discourages the use but doesn't make the use fatal. That would be the balance that you'd find. But apart from setting whatever that rate is, if you say that it must be collateralized by X set of securities, then I don't see why all these other demonstrations.
It's not really all these other. Is the first one, and the word demonstrate. And I think it conjures in the mind that you have to almost, you have to prove, you know, you have to get a letter from the bank to say that you can't get it. Whereas it's more a reasonable representation that they have tried and have not been able to. There's some language you can find that
Is the issue really, Minister, whether you have access to financing elsewhere or whether you are satisfied that the institution is facing a liquidity crisis or a liquidity issue? I mean, in other words, it's a question whether they've gone around looking for money elsewhere that they must show, or must they just satisfy the central bank that they are having a liquidity problem, for which the only available solution.
No, the central bank shouldn't be the first place to go to.
No.
Right? And that is what number one is trying to establish. That you have a problem, a liquidity problem, the first place you go to is not the central bank. Central bank is the last place. The first place you go to. So I think we need one. But I am sympathetic to the point that says, if you put it that it almost suggests you need an affidavit or you need something signed by a JP to demonstrate that you did try and didn't get it. It probably makes it too cumbersome. So it's more a reasonableness test. I mean, is there any, how can we seek?
I agree you need one. I'm just not sure whether it's phrased.
Yeah, that's what I'm saying. I'm working on the phrasing to make it.
Captures the real idea you want to capture.
Yeah. Demonstrate is too strong, probably.
Effort and failed to access loans.
The
bank is satisfied that the institution is.
And made efforts.
So Minister, I'm just wanting to be sure whether what is being said here is that it is determined by the bank in terms of the threats to the financial system that is demonstrated. Now you put reasonably in, now you have a debate at that
not
point.
Necessarily
so
reasonable,
this is
but
the bank determining.
suppose it said the bank is satisfied that the financial institution has sought and failed.
All in the context of 34M's opening words, which are that the bank may, in the event of our anticipation of threats to financial system stability, do certain things. So if this doesn't present any systemic risk, they can't get in the door, right? Yeah.
I think language along those lines that doesn't put the demonstrate seems to put it at a high level. There's an interpretation of it that probably puts it at in a crisis, in the context of a crisis, puts it at a high level. I think that's a point that should be accepted.
So sought and failed rather than going to the reasonableness, which causes another set of.
And similarly, D4, remedial measures agreed by the bank are adopted and approved by the board of directors of financial institution to strengthen its financial viability. That's not something that can be done quickly. You know, these are I have seen these things in reality. It's weeks of back and forth between the central bank and the institution and its board.
If you're looking at a financial stability crisis, you need to deal with that fast. The question of what remedial measures are even appropriate to try and solve the issue within this institution will require some analysis by the relevant department of the bank. There's going to be a period of time that you have to look at that and then design what that is. I'm not sure that can be a gating item for emergency assistance to keep the system from coming under stress.
Chairman, is that about changing the are adapted to will adapt so it points to the future? Because I think that's what Member Bunting is saying.
I mean, maybe it could be an undertaking to implement such remedial measures as the bank may consider, reasonably consider appropriate for addressing the problem. So what you get at the outset is a commitment, an undertaking that you will adopt them. But to say that you're going to agree what they are, and it suggests you have to know what they are first, and that is not a... Yeah.
So I really don't think these these types of requirements match the emergency liquidity assistance. I say, as a practical matter, what will likely happen, that the bank will, or the financial institution rather, will be in some sort of liquidity crunch, and it's usually because the system is in a liquidity crunch, and it will have some security, usually a government security, on its balance sheet that it would normally be able to use to collateralize liquidity in the market. But because everybody is scrambling for liquidity, nobody is interested. It takes that now to the central bank.
I understand the scenario that you're sort of painting to make the point, but the scenario could be different, right? It says the opening to 34M, the bank may in the event of an anticipation of threats to financial system stability. It could be because a large entity, is for whatever reason, is about to enter some liquidity challenges on its own. And if that could have a systemic effect, then this clause applies. So here you have a situation where it's a institution and this is not something that's affecting the market overall, right?
Well, it depends on the institution. Some institutions by themselves are too big to fail. In our system, an NCB or a BNS by themselves would put the whole system into crisis, into chaos. So, it doesn't necessarily have to be the entire system, because the
it
bank,
could just be one. That's the point I'm making. It could be one. That's the point I'm making. And I'm just wondering. I would love to see how other, for a country that has been through what we have been through, this is not something that I necessarily want us to be mavericks on this clause. I'd want to see what other people have before we were to remove anything like that, because I think you would want to make sure that the institution, and it doesn't apply in all cases, but I guess we're thinking about different scenarios.
The key is, though, you want the provisions to be efficacious to protect the system. That's really what we're trying to do. We don't really have instances, I think, of persons getting liquidity from the central bank who shouldn't have got it, and we all regret that. I think it's more a question of have we got an efficacious intervention system to protect the system, mechanism to protect the system where there's a problem. And we don't want to
Minister, trust me, I read this.
I hear you saying it's going to take days
by
before
a bureaucrat,
it's going to
not by somebody who has real experience of managing a private institution through a liquidity crisis.
And believe you me, if the bank thinks this institution can stand on its own, they ain't getting through the door. If the bank feels that this institution can stand on its own and is trying to use them, they're not going to get through the door. I mean, that's my experience anyway. But what I would suggest is for 4, we could just recast 4 slightly to say that provided that the board of directors undertakes to implement such remedial measures as may be developed by the bank with a view to addressing the problem, once those remedial measures have been identified.
And I think that's what they intended. Because when they use the word approved, they're not using the word adopted. Almost sounds like it could be implemented, but I think that is aiming to achieve exactly what you said, because it's approving the measures. Implementation may take a while.
The thing is that the measures may not have been developed. That's
exactly.
Point. Yeah.
I understand.
The bank must agree the measures. There has to be an evaluation, analysis, some planning done around these measures to convince the bank that they're going to be effective, and therefore, all of that takes time. It's like saying, the building is on fire. Tell me what is your evacuation plan that I can approve it before I send the fire brigade.
Chair, if I may just comment.
That's a good analogy, Member Bunting. This is a case where you're using your creativity well.
If I may just comment here, Chair. Administratively, what we are setting up is a system where we have in place recovery plans for each of those potential borrowers from the emergency facility. So for those who we don't supervise, who are supervised by the FSC, they are required to prepare and have FSC approve recovery plans and lodge a copy with us, so that in a crunch, we already know, we already have a board-approved plan, recovery plan, which can help to buttress our own evaluation of the need for liquidity.
Supposing, Mr. Robinson, that's a recovery plan which anticipates a particular series of events. And supposing what has hit this particular institution, which is systemically big, is some massive fraud that they were unaware of, you know, a Nick Leeson type situation or something where they've incurred undisclosed losses in some suspense account, which somebody discovers and all of a sudden they don't have any capital, you know, or they don't have any, I don't know what it might be, but I'm just saying
it's hard for any recovery plan to anticipate every possible threat.
Chair, through you, Chair, I'd like to make some comments which I think it will be useful for the committee to take into consideration on this discussion. One is the fact that the country is currently now looking at a special resolution regime for financial institutions. This would cover the banks, this would cover the large systemic non-bank institutions like the securities dealers and the insurance companies. The plan, one of the objectives of that special resolution regime is to try and minimize moral hazard that comes about when the public purse has to be used to prop up a failing financial institution. And if you might permit
Mr.
me,
Roper, I hate to
Bunting.
interrupt you, but that's something quite different. You know, a resolution you have already encountered insolvency.
Resolution is different, but the regime itself deals with other matters.
If you have an effective emergency liquidity assistance, you never get there. This is to ensure we don't have to access that system. So, you know, I'm trying to save you time describing all what that system is.
No, I appreciate that.
My interest is avoiding the institution having to access that system, because having to access it means there's been a failure of regulation, a failure of management, multiple failures. This is what we want to avoid. So, to me,
let me give you some comfort, Member
Bunting.
Work
on the things to prevent us getting there.
The regime, actually, strong, robust resolution regimes have in them requirements like what you speak of. These are, you have a successful resolution regime where you build in safeguards to prevent the need for resolution. One of the important requirements is for financial institutions to have their recovery plans and resolvability assessments. So some jurisdictions have what they call a living will requirement. Institutions need to be able to plan for how do we continue. When we have a crisis, when there are shocks, how do we continue? And they also have to have plans in relation to when they are gone concern. So there's a living will dealing with going concern situations, and then how can you exit the system? So it's not only about dealing with the failure, but what are the things that can prevent the failure to start with, which I think that's what you're trying to achieve with your comments. So what I'm saying is that that regime will impose a discipline on the financial institutions to basically have pre-prepared plans. What do we do in the event if certain eventualities occur? So even the scenario that Member Golding mentioned, which is you have a Nick Leeson type fraud, and basically now there were unreported losses that you're now contending with. You find yourself in a situation where liquidity is tight. Yeah?
Market hears about it. That's when you're going to be tight, right?
Exactly.
Yeah. I mean, you may, if nobody knows about it, you may be able to work your way out of that hole from a solvency perspective.
So whatever the cause is, you still have a liquidity problem at the end of the day. So what are the plans? What are the contingencies? Where is the backup funding to come from? How can you use any assets that you have unencumbered to secure liability through advances and loans? So financial institutions, what's happening now in terms of international standards is that financial institutions are being required to be in a state of readiness. And that's by having this discipline of doing these recovery plans.
This contemplates you'd have blown through all of that.
All right, just come in.
Chairman,
Can we?
Chairman.
Yeah, Senator Brown.
Yeah, I think we're at 16B D4, right?
Yeah.
And much of the discussion here is that we want this in, is what you have asked us to put it. No. They have asked us by submitting the bill.
Oh.
They want this in. And what I understand the discussion so far to be that it is too restrictive, and it could be opened up by saying remedial measures agreed by the bank will be adopted and approved. In a funny way, we go to a lender of last resort, the IMF. They say we'll give you some money up front, but we're going to require you to do this down the road, probably starting immediately, probably starting next week, probably this every month, this every quarter. And that's what I read us wanting to achieve in 4. And so the language that is there now could be tweaked to say that you will do so and so, you will adopt and approve such and such.
Yeah,
and if we do that, I think we don't have to spend all this time here.
Yeah, the board of directors of the bank, of the financial institution, undertakes to adopt
such remedial measures as may be developed and required by the bank.
Let's look at that, and if it doesn't work, come back. But I don't see why. I'm not seeing right now why it doesn't. But it's these are such technical and important matters that you cannot sign off on them just like that, right?
Chairman,
so just take a look at
it. When you look at the first 3,
yeah,
the first 3 suggest that there ought to be an immediate reaction,
yes,
in terms of providing the support. But if it flows into 4 suggests that there ought to be some future actions taken, which you can't tie all of them together.
Yes.
So we have to change the wording of 4 to suggest that there are some alternative strategies that must take place in the future for you to contain stability of these institutions.
So let us work just in the interest of moving forward. Yeah.
So
yes.
I was just wondering, Chair, at 4, what would be wrong then in just simply saying remedial measures agreed by the bank are approved by the board? If the board is going to undertake, why the board wouldn't just approve it? I'm just asking that question.
This contemplates that the remedial measures must be identified and agreed in order to get the liquidity assistance. And I'm saying that isn't practical. What is practical is you sign an undertaking that they're going to allow the bank access, they're going to come up with a remedial set of measures, and you're going to implement them. And when you sign that undertaking, those measures haven't yet been identified or fleshed out, but you're committing to implementing them, yeah, or agreed. Yeah. If they don't implement them and they breach the undertaking, then that triggers the kind of other action that the supervisory role of the bank entitles it to, there's the ladder of enforcement or whatever it's called. Yeah.
And this is giving permission to the bank to lend. I mean, the bank can still decide not to. Huh? I mean, is at your discretion anyway. So
we look.
Can you? Yes, yeah. Please give strong consideration to it. Yeah.
Yes. Okay.
All right. Moving on to 17.
Okay. So 17, Chair, seeks to amend Section 36 of the Act, which provides that the bank, in any fiscal year in which there occurs an event declared to be a national emergency, may make temporary advances to the government under certain conditions that it shall not cumulatively exceed 5% of the average of the recurrent revenue for the last 3 fiscal years, the 3 fiscal years preceding the event, that interest will be charged at market rates, that the repayment should take place no later than 4 months after the end of the fiscal year, and that no further advances will be made in this subsequent fiscal year until the advance has been repaid. And this contrasts with the current provisions, which provides that the bank may, in any financial year, make temporary advances to the government, which shall not exceed, in the aggregate, 30% of the estimated revenue for that financial year, and that the risk, which should be repaid no later than 3 months after the end of the financial year. And then the current provision is that where such advances are not repaid, the bank shall not make any further advances until that is done. I think the key issues that have been raised relate to the definition of national emergency, and which have parallels in the FAA and in the Constitution. I think our intention here is to define some latitude for the government to have access to liquidity, to funds, in the event that there is a break in the normal course of economic events, that, if for some reason, let's say taxes can be collected, there is a source pre-authorized where the government has access to credit from the BOJ equivalent to no more than 5% of the expected revenue, of the average revenue for the last 3 years. So the issue of defining under what circumstances these advances may be made has not been fully agreed, but the intention was to, without defining to exactly what the emergency is.
Right. So the issue of national emergency is certainly the written comments that were received. That's where I guess the discussion could be centered. And the idea is that national emergency here is being thought about in a broader way than simply natural disaster.
Yeah.
Right. It could be a cyber attack, and those things are very, very real. On the payment system or something like that, it's things that we can't even think about, but it would rise to the level for the Prime Minister to declare it. Now, we could look at elevating what declaration means. Right? We could involve the Parliament somehow or so on, but the idea is not to constrain national emergency to be defined in one dimension, like a natural disaster. It could be anything.
My point was that there's no legislative regime that was being referred to here, which empowers the Prime Minister to make this declaration. So where is this declaration to be found in terms of its legal status? And I just pointed to 2 different areas in our law where there is something of that nature. There is the constitutional one, and then there is the one to do with hitting the whole fiscal program off course, which is in the FAA. But I thought if you're going to use the word national emergency,
we could define, not define, but we could say the Prime Minister, a national what we mean here is that he comes to Parliament, or she, and.
But this is essentially a situation in which the ordinary revenues of the country have been substantially impaired due to some kind of shock to the system, not necessarily acts of God. Can be any
Just
kind of any kind of
it
shock.
could be any kind of
it
shock.
It could even be, you know, something happens that
we were planning to raise a bond next week, right? And things were all lined up for that. And there's a terrorist attack in New York, and the markets are closed,
right?
And we can't raise the bond. You know, we can't even think of the eventualities, but they exist, where the government may need to turn.
I just think they're using the declaration of a national emergency as the thing that all this is hung on is too, from a wording perspective, invokes other statutory or constitutional arrangements which weren't really, I think, at play here. So I think that is why it seemed to me that we, you know, whether this needs to be, I mean, you're putting it on the Prime Minister to be the one to say this, you know.
Well, the Parliament has passed some fiscal rules, which says you can't move this and you can't. So the Parliament has set a barrier, set a outer limit. Now, how does this fit within those fiscal rules? Because those fiscal rules does give a little leeway.
If there's a crisis.
If there is a crisis. So does this fit with that rule, or does this expand the windows through which we can tackle a crisis? I'd love to see how if it is consistent with those.
Are you want to go, John?
Yeah, I was going to say that this proposal actually reduces the amount that the government can borrow at any time. It limits it to 5% of the average revenue for the last 3 years, moving from 30% of the estimated revenue for this year. So, I mean, in numerical terms, I think the average.
But in terms of how it applies, in terms of the trigger, he's saying under the Financial Administration Audit Act, as amended with the Fiscal Rule Amendment, there's a provision that if the Auditor General certifies that there's a period of national emergency, that there's an escape clause from abiding by the primary balance or the fiscal balance target.
From a transparency perspective, that might be a better model to say, if the Auditor General certifies that there's a fiscal crisis which has impaired the normal revenues of the country, the Bank of Jamaica may make these advances. You know, at least that's inconsistent with the approach used for the fiscal rule. And in a sense, what you're doing here is something which is, you know, it's a central bank lending to the government.
This is we have to be careful here, you know, because you remember the fiscal rule deals with a provision where the country is continuing. I mean, it's just the fact that you're not going to hit your target. That's all. This is a situation where we're saying that the country cannot continue. It cannot fund itself. And that we have to be careful in terms of.
But the question is, who should certify that the revenues that this has happened?
Mr. Chairman, I must tell you, I am deeply suspicious of a Prime Minister declaring any national emergency. The Constitution already provides for the Governor General to declare states of emergency or public emergency, and it covers a wide range of things. You know, it's not just the Tivoli type operation or state of war or earthquake, hurricane, or flood. It says that it includes that a period of public disaster has arisen as a result of outbreak of pestilence, infectious disease, or other calamity. Now, a collapse of a cyber attack, for example, would certainly qualify as another calamity.
Being constructed, the cyber attack wasn't taken into consideration.
Right, but it's exactly, which is why it says, or other calamity, whether similar to the foregoing or not. So they clearly anticipated that there were things that you would not see. Now, in this scheme, it contemplates the cabinet goes to the Governor General. He can declare it, and within 14 days it comes to the Parliament for the extension to be approved or not. We already have that scheme. Why are we going to invent this new one now that excludes the Parliament, excludes the Governor General, and concentrates that power in the Prime Minister? I am not in agreement with any such scheme.
Of course, the point can be made that that scheme that you just read is a scheme that leads to the suspension of constitutional rights in the citizen and access to the court. So this is really this is a trigger that doesn't do any of that, but rather allows the BOJ to lend up to 5% of the average of the last 3 years' revenues. So it's the implications of it are somewhat different. But I do think that in keeping with the whole fiscal prudence, and you are making advances to fund the government, which is something which is really not considered the norm. The government must fund itself through revenues, not through creation of money from the BOJ, giving it money to it. So it's an abnormal situation, and I don't think it should be vested in the PM to say this is the situation. It should be in keeping the fiscal rule. Why doesn't not have the Auditor General say that there has been a crisis which has had a material adverse impact on the revenues of the country, and that should be sufficient, warranting this intervention. It's in an independent, unimpeachable office.
It's trying to balance. I understand what you're saying, but trying to balance the stability of government, which is important. I mean, our constitutional provisions give stability a huge premium, right? Which is why we have our system as opposed to the system in Italy or Israel, for example, which is not stable. The compromise is in reducing the amount to a very small amount. So it's not, it's 5%. It's a small amount. And
where did that come from?
No, just wait. No, just reducing it and given the
you can pay it back in debt, it says, or cash. So it's ultimately going to come to it's going to be on the fiscal purse. So Parliament should bless this thing. If this thing shouldn't just be done, there should be a resolution of the...
I don't mind. I'm personally, I'd be open to that. I think that we need to be able to... Our system is designed that government continues. And the circumstances under which something like this would be used, especially in the context of the fact that we have fiscal rules and so forth, would be something that is difficult to anticipate, but that could...
It hasn't happened.
It hasn't happened.
In recent times.
In recent times, exactly, and God forbid. But if we had something that says the Prime Minister, the action might happen, but he has to come to Parliament and table something and have an affirmative resolution or whatever. Huh?
So in other words...
Our Parliament meets once a week.
No. Parliament can be called at any time.
Huh?
Parliament can be called at any time. So I would think if the circumstances arise and the Prime Minister is so minded, and the Prime Minister is so minded, and the Prime Minister is so minded, then he comes to Parliament with a resolution.
5% for fund the election.
he comes to the Parliament with a resolution for affirmative vote. Then he goes to the Bank of Jamaica.
And with this system, you wouldn't even know. This could be a letter that he writes to the governor, saying, I am declaring that a national emergency. Please deliver your check to Miss Dr. Clark.
But Chair.
Here's the calculation. Last 3 years, 5%.
Chair.
Yes, I'm agreed.
I get from the clause, it does suggest that this happens in the case of an extreme event. And, you know, we just spent a lot of time speaking about when private financial institutions find themselves in difficulty and how we must not make it too difficult for them to be rescued. But when the country finds itself in difficulty, we find it hard to put our trust and confidence in the Prime Minister to make this decision. I don't believe we can operate like that.
I wonder why the money bills were brought.
I genuinely don't believe it. Almost sounds as if we're willing to say, let's put our trust in the banks when they run afoul that it will work out. They need this money. No, we don't have to sign them up to any preconditions. Let's give them money. But if the country and the Prime Minister deems a national emergency, we find it difficult to do 5%.
5% of the revenue.
Those comments reflect the ignorance of history.
No, it's not. But let me tell you, this is the reality, Chair. You know what I have found?
Allow him to speak.
You know what I have found? Because we have had bad events in the past, right across both administrations. I appreciate that we put systems in place to protect from recurrence. What I have seen time and time again is that sometimes we go too far and they end up complaining about how the same system we put in place stifle us from doing anything. I would just urge caution, because sometimes, especially when we're in opposition, we speak as if we'll never become government again. I understand why, but sometimes it doesn't work well, quite frankly. And I don't think this has gone too far.
Well, I must say, I don't think the two things are comparable. One is a situation where there's a potential systemic crisis and an institution needs some immediate liquidity support, and the bank is inclined to give it to protect the financial system as a whole. This is a situation in which the government's revenues have been compromised due to a crisis. And the question is, how do you ensure that that is not abused? Given where the temptation of poorly managed economies to use central bank financing rather than to finance operations of government, rather than biting the bullet and doing what needs to be done to run the country properly. And we don't want to go back to that to the extent that we are coming from that. Yeah. So all we're talking about is an appropriate mechanism which is transparent and which is also suitably independent to ensure that the need really exists. And even if we don't have a quantitative metric to say this must be, you must have shown some kind of reduction in the revenues by over X% to trigger this. No one is saying that, but at least have the thing certified or approved in a transparent way. Yeah.
Okay, so I feel that we need to keep it within the domain of the Prime Minister with regard to the goal of maintaining stability. But I also believe that we lose nothing and we could actually gain if we have some measure that ensures that there is transparency and accountability, that the Prime Minister has to account, right? So, and as long as you say, Parliament can meet any time, if we had it that the Prime Minister has to come to Parliament, move a motion that has to be passed, and in a motion questions can be asked, debate, etc., etc.
Well, a debate on a motion,
no.
yeah.
Huh?
You'd have a debate on a motion.
So it's transparent, but it's the Prime Minister, not the...
Why would it be the Prime Minister and not the Minister of Finance?
Why is it not the Minister of Finance? So he's in...
Right. No, in that case, it would be the Minister of Finance, yeah.
But could I just ask, as a practical operating matter, Mr. Robinson, the consolidated fund account is at the Bank of Jamaica. If the government drew a check that it didn't have funds in the account, would you bounce a check on the consolidated fund?
First of all, checks. Let me answer that question. First of all,
I mean, I'm using check
you
literally.
passed the law as Minister of National Security, right? That you outlawed
Cash.
Exactly. It was you who did that. So we make payments by electronic transfer.
Right. I'm just using check as a representation, right? But if you try to make a payment for which you didn't have, you would bounce it. The payment would bounce. I'm asking you, would it or would it not?
You need immunity to answer that?
Is it secret? I don't think it's secret.
No, but
must the consolidated fund be funded in a credit balance to sufficient to draw to allow?
That is the expectation, that if a payment is to be made, then the account has to be funded. Else
it won't.
So would you not make the payment if the account wasn't funded to the extent of the payment?
Can it go into overdraft?
The government just wouldn't pay. I mean,
we don't do that anymore.
No, the central banks, quite on the contrary, used to allow and we have recent history in the Caribbean, in Barbados, etc. Yeah.
In 2009.
No, in Barbados it was happening up to 2 years ago, right? So, which at one time was a very fiscally conservative country. So we've seen it happen. This is just, but when faced with that pressure on a given day, an operating officer at the Bank of Jamaica would be under a lot of pressure to bounce a payment or not make a time-sensitive payment, for example, like salaries, on the basis that there is not a debt payment or something that will trigger precipitate a crisis. So I'm just trying to understand, because there will be a lot of pressure on that individual. So is there a protocol in place for that now, before we pass all these, whatever additional?
Well, with this, it would be, I think you wouldn't be able to do it. Why are you taking so long to answer that question? Let's get us worried.
One and Lambert called strike because the people don't get paid, and the governor down there don't allow the money, knowing that next month money will come in. These are some real issues that I think being raised. Maybe he wants to duck the answer, but...
And that sounds like a case where we have an exceptional advance.
Are the aisle boat,
the
boat going to Petrojam? Swing by your place on the waterfront and ask you have the money?
Avoid that last statement.
But, Member Green, just by keeping it with the Prime Minister or making it the Minister of Finance, but requiring an affirmative resolution doesn't take away from your point. In fact, you're preserved. The point that you're making is preserved. Do you see that?
I take the point.
Yeah.
I take the point, I guess.
So meaning we're keeping it within the executive and not making it...
Provides for an overdraft facility. That's what 36 kind of does, right? It allows the bank to make temporary advances to the government.
In a particular scenario?
I don't know what the scenario is. It just says the bank may in any financial year make temporary advances to the government, which shall not exceed in the aggregate 30% of the estimated revenue for that financial year.
No.
Yeah.
Yeah.
Right,
exactly.
no. Yeah. So we're trying to move that to a crisis-based regime and a much less generous regime. I'm not sure why we're capping out at 5%, where that number came from, but you're
just
okay.
in consultation with advisors and what obtains in other countries. This scheme means it's compatible, and it can only come after the fiscal responsibility scheme. A government has to have the institutional mechanisms to run responsible policy before you can put something like this in place. And if you're running responsibly, financing yourself in the market should be a possibility the vast majority of times, even if you have to pay up. Here but even with the market possibility of financing, you still need a last resort. Okay, so here there's an emergency, and we're saying that the ability to go on, you can issue instruments very quickly, very easily. You have stuff on the shelf, you pull it off, and we're saying that that option is available, and for whatever reason, that option is not deemed sufficient, or it's not fast enough, or...
There's no provision in this, like paragraph 1 in the other one, where you have to show that other sources of financing are not available.
No.
You don't have that.
No. But it's necessary in the interest of sort of stability for you to have this last resort that hopefully you use once in 30 years. But it has to exist. It needs to exist.
Yeah, man, let me tell you one other concern I have here. I've seen in other bills, I was struck it out elsewhere, the insertion of the Prime Minister, and I fear that I believe where there's a national emergency to be declared in the country for anything, any reason, that the Cabinet in Council, that the Governor General in Council should be the one doing it. You know, the Prime Minister and his Cabinet say, this is how we need to go on advice of the Minister of Finance. Then they go to the GG and then make the push to the Parliament for the affirmative
but
resolution.
But as a practical matter, if the Minister of Finance is coming to Parliament to move a motion for accessing emergency liquidity under 36, right, for the approval of that, he would have got Cabinet's blessing on that before he comes. Yeah.
I hope so. Yeah. But I don't know that you are the chairman will always be the Minister of Finance. So
I'm not.
and I've seen, especially in this week, Minister of Finance feeling very powerful that they have all that authority. So I'd want to see it coming through because the national thing, the Parliament approved and the GG declared that there's a national emergency and it goes. So I don't want to insert the Prime Minister, even the Minister, in the declaration.
No, if we do it, having the GG in there, you can have the Parliament. It would be...
It's not a declaration system.
Somebody brings it to Parliament, right? Somebody has to bring it to Parliament.
For this.
Somebody has to bring it to Parliament, and then Parliament approves. If it's so, right? Parliament, and by Parliament, remember, Parliament is bigger than Cabinet. You have to get not just the Cabinet colleagues, you have to get all the parliamentarians, you have to get a majority of parliamentarians to back it.
And so it would be something like where the minister is of the view that there is a crisis which has impacted the revenues of the country, he may, subject to be an approval of a resolution of the House of Representatives, request in advance. That won't be in there at all.
You got that? All right, so we bring it to Parliament, and Parliament move a resolution, and on the adoption of the resolution, then we have the authority to go ahead. Right? In that case, it will be the Minister of Finance. I think that...
So, Minister, one question I have on C, which allows the advance to be repaid in cash or with marketable securities. If you repay it with marketable securities, that becomes a termed out debt that has been added to the... That doesn't exist in the existing Act. In the existing Act, it has to be repaid. And you can't do it again unless you've repaid it.
Just that what we don't want, and if I may jump in and you come after, whenever the central bank gets, even though it has given cash, whenever it gets cash, the very action of getting cash can affect monetary policy. That is meaning that if they have to go out and buy securities, that is a monetary policy action. But you want to come in there? I don't know if...
Yes.
They provided cash. They should get back cash. Otherwise, the system has had a net outflow into it of cash.
Which, if we do get securities, those can be sold. So in that way, you reabsorb the cash that you injected. So, yeah. I mean, so the whole idea.
And you've increased the public debt.
Yeah.
If it's done by way of marketable securities, then the public debt is increased by 5% or up to 5% of revenue.
Yeah.
You know, whereas if it was paid back in cash, that wouldn't happen. Yeah. And you may or may not, if you get marketable securities, go and sell them to get back cash.
You don't think that because we are narrowing it here to cases of emergency, that having that flexibility isn't important? I mean, we're saying you have to pay back within a year or less than a year, as the case may be, because you could borrow the money in October.
My thing is that by allowing it to be paid back in marketable securities, those could be 20-year bonds. I mean, you know, in other words, I would have preferred to say that you must pay it back maybe in over 2 fiscal years or something in cash, or, you know, rather than having a very onerous thing. But I mean, it does seem to me that this is just giving you an out to effectively borrow on a long-term basis from the central bank.
The idea of this clause is that in the normal course of things, there will be no lending to government. The exceptional case has to be declared officially, which then allows us to advance this 5% of the average of revenues for the last 3 years. As it turns out, numerically, this is not a huge amount. This is like about 25 billion, which has to be repaid within a matter of months.
Revenues here includes grants?
My estimate is just based on tax revenue.
Tax, okay. I was going off of the overall revenue.
Yeah, so this is half of a month's revenue. So I guess if we limited it to cash, it means half a month's revenue. You could ostensibly borrow the money in the market and then use the cash to pay back the bank. So do we lose anything by making it cash? I mean, we lose flexibility.
Why are you permitting the repayment to be made other than in cash, if you've advanced cash?
Not sure where this flexibility came from, because if we got cash, if we got securities, we would then sell these rather than have a build-up in claims on government on our account, on our books.
Right, but the effect of that would be the government would have increased its indebtedness through this advance on a long-term basis, as opposed to this being a short-term reprieve, which is to be repaid. In other words, you're essentially creating debt, long-term debt, out of a temporary advance.
Remind me, what's the definition of marketable securities in the Act?
It says, well, I think we had some discussion on it, but in the bill it says such securities as may be agreed between the bank and the minister that can be readily bought and sold at a fair price. So anything that there could be a buyer
so,
for.
You know, we're kind of reintroducing a flexibility when the direction the regime has been moving in is more and more rigid and making it more and more difficult, in a sense, for a governor and a minister to just agree to, you know, run with it. So we don't want to get back there. So let us, and you know the example I use, Mr. Green.
I do.
because I don't want.
I like the liberation.
You know, I don't want you to say I'm being political, so I am careful the example that I use. But you know, we have to learn from history, and we're making these laws that will go way beyond when any of us are here in our personal capacity. So we have to anticipate, you know, rogue persons being in positions of influence.
look, let's just if you can come up with a good reason why we should keep the marketable securities.
Chair, the provision allows for extending the period for repayment in 2A, you know? So if it can't be repaid within 4 months of the next fiscal year's start, which is what you can, and it's not even any outer limit for how long that extension is, which is another big loophole.
Oh man, it says you can't. The bank shall not.
Oh.
Shall not. Which is why, because...
Oh, no, so what? So in any... unless the outstanding advances have been... All right. Thank you, yeah, thank you. What about the current year? So the question really is, if the whole regime is supposed to be one of, why are we allowing this to be added to the debt, as opposed to saying, pay it back in cash? You got it in cash, pay it back in cash. If 4 months is too short, you know?
Look, I don't have a problem with that. Yeah, let's take out marketable securities unless you can
come with a good
good reason. Yeah. Okay. All right. So,
but if you sure, and clearly, is 4 months a reasonable time frame? I'm genuinely asking.
We have 4 months in the existing bill, in the existing act, for much larger sums.
The only thing is, supposing you borrow this money towards the end of the fiscal year, you know?
Now, and that's why marketable securities is there.
Yeah, that's why I thought there was an option.
Or, in essence, moving...
I wouldn't want to see...
Anyway.
I think it just allows for budgeting of it, you know.
Yeah.
And the time that it can be repaid early in the next fiscal year.
Right.
I mean, these are temporary advances. The idea is that the government is funded by tax revenues.
That's right.
And we're not printing any money.
Yeah.
Another comment on, as raised by Member Golding, in 36(2)B, which will help to clarify some of the issues, he suggested that we take out in any subsequent fiscal year that phrase. So that would clarify the intent that no further advances would be granted unless and until the outstanding advances have been repaid. So we just take out in any subsequent fiscal year for clarity.
That's fine, yeah.
As suggested.
Okay, 18.
Yeah. So clause 18 describes the limitation on the power of the bank to purchase securities issued or guaranteed by the government. And this is a continuation of the theme of limiting the extent to which the bank can fund the government, you know, either through direct advances or through the purchases of securities on a primary issue. So Clause 18 seeks to amend Section 37 of the Act, providing that the bank is prohibited from purchasing or otherwise acquiring on a primary issue securities issued or guaranteed by a GOJ. So the bank, however, has a discretion to purchase or otherwise acquire securities on the secondary market if such securities such amounts as may be determined by the bank for the purpose of replacing maturing securities, implementing monetary policies, and to support the maintenance of financial system stability, which is to buy securities from an institution that needs liquidity. So this contrasts with the current provisions which prohibit the bank from, in any financial year, purchasing or acquiring on a primary issue securities issued or guaranteed by a GOJ of a nominal value exceeding 40% of the estimated expenditure of government in that financial year, or some such other percentage as the House of Representatives approves. So again, this extends the limitation on the bank from providing credit directly to the government but allows for the acquisition of securities on the secondary market for these specific purposes.
Existing 37 didn't speak to secondary market purchases at all.
No.
It just said you can't
Right.
you can't fund primary issuances of the government. Yeah. So now we're making an explicit, we're keeping the prohibition on funding primary issuances of the government, but we're also saying you can do secondary market purchases for these purposes. Yeah. And I had made some comments on this because I thought it lends itself to manipulation if it's not in the way it was currently conceived. I don't know if you had a chance to look at my comments, but a primary issue can easily be converted into a secondary market transaction.
You want to respond to his comments? Yeah.
Yes, we looked at it and actually agreed with it that it is possible to circumvent this restriction by issuing to a secondary party and have the bank then buy from that party. So we support the suggestion that in the new section 37.2, for clarity, there should be listed at paragraph A to D the 4 stated purposes for which the BOJ can purchase GOJ issued or GOJ guaranteed securities on the secondary market.
That's proposal of just to set it out
better
in a list.
Yeah.
You know, but I thought the more important thing was how defining what a secondary market transaction is.
Yeah.
You know, so as to avoid the a manipulation of this in the way that I had described. And there are other ways. I just came up with that one at the time. Yeah.
As unrelated prior transaction and
right.
so on. Yeah. No, we support those suggestions. So
So Chairman, if we could just define secondary market transaction.
Right, I saw that in your comments. Yeah, secondary market
and
transaction.
And to set out what you have as a paragraph in subsection 2, just list them out. Yeah.
Okay. All right. So that brings us to 19.
Thank you, Chair.
Which is 19 is actually the independence provision. I mean, can go home now.
Right. So Section 19 deals with the power of the minister to give general directions. And it seeks to amend Section 41 of the Act to specify that while the minister may give to the bank directions of a general nature that to the minister appears necessary in the public interest, the minister may not issue to the bank directions with respect to monetary policy or supervisory matters pursuant to the BSA. This elicited.
So he could establish some policy around the canteen concession, for example.
Yes, not too specific.
Or the bank's art collection. Broadly speaking, put more capo in it.
Where does exchange rate policy fall into this then? You know, it precludes him or her giving any instruction,
but
directions in relation to
so it says not monetary or supervisory, but financial policy. Would that fall within general directions?
Since we have a financial policy committee.
Yes, but it doesn't exclude financial policy.
I mean, I think
the primary functions of the bank are monetary policy and supervisory. So he's just saying that in their that the bank is set up for that, for monetary policy and for supervision. And in those, the BOJ has independence of operation and implementation. But, you know, there are other areas where the bank is
You mean like compensation policy, for example?
Yeah.
The minister could say that the government is on has a general cap or ceiling on wage
Correct.
agreements that shouldn't exceed this, for example.
Correct. Things of a general nature that don't have to do with their primary functions.
Or pensions or something else.
Yeah, well,
I'm hoping he wouldn't have to say some of those, but.
Well, where would the foreign exchange market come? You know, that's obviously a very sensitive topic in our society. And it is, no, I don't, no, it's not. It's to do with the use of the reserves.
well, foreign exchange, yeah, it is it is connected to monetary policy. What is happening is that there's no, as opposed to the distant past, let us say, or whatever, exchange rate policy is not the primary occupation. The exchange rate is an output and not seen as an input. The primary is going to be on price stability. The central bank, when you therefore give independence on monetary policy, it includes all of those areas. But and which includes, you can't effect good monetary policy if you don't have sufficient reserves. So you have, the central bank just needs operational independence in the management of reserves. Now, the advocacy doesn't stop. I mean, you can advocate, and the Parliament advocates, and stakeholders advocate. But the truth is that putting it in legislation that there be no directions on monetary and supervisory policy matters, even though one would be hard pressed to find sort of written directions anywhere, is of supreme value because it has the power of law. Yeah.
What strikes me here is that we're giving it one hand and taking back, because the inflation target is itself tied up in when you set that target, whatever monetary policy they must follow, it flows from year 2 to 4 or 4 to 6. So in a sense, I've been said in the legislation already that you set the monetary policy. I don't think we need that's why the bank of all of this independence is to set the monetary target, the inflation target. When that inflation target is set, the bank must now go and do what they must do to achieve your target. And that may include monetary policies, it may deal with their supervisory matters. So in a way, you are influencing that by the target you have set. 41.1 says you may give such direction of a general nature. But if the core function of the bank is going to be the inflation target, you have determined that by I don't think we need to say you have any other role, because that's what I thought we were taking the minister out of the bank.
You're saying 41.1?
41.1 is not necessary.
No.
Because you have already earlier set the target. They must now go develop the policies.
Senator, I hear you on that, Senator Brown, but there could be from time to time matters of a general nature that affect the public interest that have nothing to do with monetary policy or supervisory matters.
There's no definition of monetary policy in the bill, in the act, right? It's not defined. But we're saying it's whatever it is, it's something that the minister can't give directions on. So if the minister, for example, decides, well, I want to liberalize the foreign exchange market some more, and I want to make all cambios full authorized dealers, or if I direct you to do something in relation to that market, say, which is quite different to what pertains now, because I want more competition or some such thing. The bank might say, well, that's monetary policy, so you can't do that, because they may not agree with it for whatever reason, And then you have there's a debate as to whether it is or it isn't, because if monetary policy is that which achieves price stability, the question of how the competitive arrangements within the foreign exchange market don't clearly have an immediate connection with price stability. So I'm just saying it may be useful to be clear.
But I would say no. But I'd say to you that on those things, the bank has an interest in the effective functioning of these markets, or else they will not be able to achieve their objective. If anything, it's the government and various governments that stands in the way. The stuff with monetary transmission and competition and so on. The government needs to get rid of the taxes. So the bank, we're not removing the accountability function from the bank, or the accountability powers that the society has, that it can hold the bank accountable. And it's through that accountability framework that we can get the bank to move on matters that we consider to be important, whether those matters are that there isn't sufficient market transparency in the FX market, and therefore we need a trading platform, a trading system. One doesn't have to have directionary powers to get that to happen. The accountability relationship.
That may be so, that the bank's interests are aligned with a more competitive foreign exchange market currently, or whatever. I'm just saying that one may be able to imagine a situation in which a minister has a desire to give a direction to the central bank, and the question arises, is it or is it not within subsection 2, right? And that will determine whether or not it's binding on the bank or not. The minister is going to want to say it does not come under subsection 2, presumably, because he's the one who wants to give the direction. And the bank will want to bring it under subsection 2 because it doesn't like that direction, otherwise it wouldn't be an issue. So I'm saying, what is the scope of subsection 2? Does subsection 2 incorporate the foreign exchange market, for example?
Guys, this is one section here in the that I in the bill very hesitant to change.
Can the overlords who watch this whole thing and are very anxious at this provision, which is the core of it all, be robust? How would they define monetary policy?
Monetary policy is a term that is I want to say it's a term that is well understood and defined. I wouldn't want to restrict it to a definition here.
I was just going to suggest that it defines actions taken by a monetary authority, central bank, to influence the conditions of credit, money and credit in the economy in furtherance of its objective of price stability. Those actions change, or the tools.
Well, specifically, does it include matters to do with the foreign exchange market? or exchange rate?
To the extent that it affects the reserves, yes. Because to the extent it affects the reserves, yes. Having a minister give directions on reserves is not compatible with the scheme.
Right.
Or the use of reserves.
Suppose it talks about the system of trading, the B-fix-it or versus some alternative system. Would that be within the general directions, or would that be, because it's related to how you use the reserves, be excluded?
No, all of that would be a part of monetary policy.
Says who? I can see that the character and personality in the minister has varied a lot over time. Yeah, the character and personality. I'm thinking of some who we've had over the years, you know, and how they relate to this may differ. You know, there may be some who are fully attuned and aligned with the purist approach to inflation targeting and so on. There may be others who have a more unorthodox approach to these things, and I'm a little concerned that where you juxtapose a permissive provision under one and an exclusionary provision under two, the area, the province of what is excluded, the boundaries of it, etc., may be contentious unless there's some clarity around it. So to the extent that the foreign exchange market and its operations are part of monetary policy for this purpose, it would be useful to say so.
You're saying somebody could test the bounds?
Somebody may take a position that I want a major policy change of direction in this area, and I don't think this is part of what is meant by 41.2. That's all I'm saying. And then you have an issue, you know. Or even something to make it clear that the reference to monetary policy here includes these things. Yeah, yeah. I'm not expecting a response now, but I'm thinking just consider it and maybe discuss it. Given how important it is.
This is the raison d'etre, so to speak. You know what I mean? Raison d'etre. So we don't look. The fact that we are moving in this direction, the people who hold the $10 billion approximately of bonds that we have are paying keen attention to what we're doing, as hard as it may be to believe.
I don't see them in here listening to what we're saying.
When you meet the questions that they're able to ask, you would be surprising. Yeah. And as long as we need to borrow, we need to make sure that. So this is a key.
And my thing is about getting 41.
No, I get you. You're getting it tighter. Is what you're saying. Yeah. All right. I'll allow me to consult on that. Right. We are at 5 o'clock. We have been ending at 5:30 on the dot. I'm going to just crave your indulgence to do another 5:30 and see what else we can knock off.
I believe in the law of diminishing returns.
So, number 20.
Yes. I have it. Thank you, Chair. Clause 20 of the bill seeks to amend Section 43 of the Act. Section 43 deals with the accounts of the bank and audits. And the changes to Section 33 that are in the bill fall under one of two categories. It's either changes to align the provisions in this law with the PBMA, or there are changes related to entrenching the independence of the central bank. So I'll just quickly run down the changes. One is the clause seeks to ensure that reference is made to the accounts being prepared in accordance with generally accepted accounting principles specified by the Institute of Chartered Accountants of Jamaica. And that's in keeping with Section 3 of the PBMA. The clause also speaks to accounts being audited annually by an external auditor appointed by the board. And that's a departure from what we have in the current Act, where the auditors are appointed annually by the board with the approval of the minister. So we remove the with the approval of the minister. The clause also speaks to Section 43, including provisions that require the external auditor to be a registered public accountant, and that is as provided by the Public Accountancy Act, and this is in keeping with Section 13.2 of the PBMA. The clause also specifies that the external auditors are entitled to examine the accounts of the bank at all reasonable times, and it specifies that the Auditor General shall be entitled at all times to examine the accounts and other records of the bank. In terms of the comments that were received, Member Golden had suggested that the new Section 43 is wholly inadequate without being supported by the robust accountability architecture in the PBMA Act, as provided by the provisions in an appendix that he supplied. I know at earlier proceedings here, it was agreed that the regulations under the Act will capture provisions in the PBMA. So I think we have addressed the concern that was raised by Member Golding.
And those regulations will be appended to this bill.
Schedule. Right.
And passed.
But just reminding, the BOJ said they prefer that they not be subject to the Public Bodies Management Act, and that those sections be added to the new Section 43. But there had been a discussion about whether it should still apply, the PBMA. Why to give a general exemption under PBMA? Had we resolved that?
Well, their position was that there were incompatibilities that they wanted to eliminate, and rather than identify them and one by one, so you could see that yes, that's an incompatibility and it shouldn't apply, and they wanted to just have a wholesale exclusion of it, which is what is in this bill. And they have agreed, I think, that some of the identified provisions which will be made applicable through regulations, which will be enacted as part of this process. Now, whether my list is the right list, I don't know. I went through it and chose the things that seemed obvious to me that should really still apply, because it is still a public body, and it ought to have that kind of external oversight, not over monetary policy and so on, but over other issues.
Yeah, so we will make sure that the regulations capture all of the relevant things in the PBMA and attach it as a schedule to the bill. It's just that the BOJ Act or the regulations are likely to be more stable over time. The PBMA is going to be amended almost every 2 years. There's a reason to amend it, and somebody's going to have to keep in mind, hey, does this apply to the BOJ or not? The cleaner thing to do is to just do a comprehensive. So we had discussed that at an earlier meeting and agreed to move in that direction.
Chairman, in terms of 20, 24 speaks to the external auditor examining the accounts of the bank. At 5, Mr. Roper read the accounts of the bank. But the word in here speaks to other records in relation to the bank. Is there a reason for different wording in 4 as in 5, or shouldn't it at 5 also be to examine the accounts of the bank? The AG examine the accounts of the bank rather than in relation to the bank. Just two different set of words.
I think
there's a lack of consistency.
5 is supposed to be broader than 4, because 4 is limited to the auditors looking at the accounts. It may be that the word of should be after the word accounts in 5. Examine the accounts of, comma, and other records in relation to, comma, the bank. But I think the intent is that the Auditor General's purview is wider, because they can be looking at other issues to do with other policies and procedures that should be, I take
but member whole thing about of the accounts, and to make it clear that we're going wider than 4.
But why not just to examine the accounts and other records of the bank? Why? I don't understand the in relation to. Yeah. Why not just accounts and other records of the bank? Because in relation to that would mean, is that some third-party entity that you?
I was just thinking, would that include things like the minutes of these committees? And I don't know. In relation to it tends to be a broader formulation, But yeah, but I don't think it really is necessary. Could accounts and other records of the bank.
BOJ.
Minister, I think we can look at the formulation and come back here on those 2 points. So I think those are 2 reasonable points. Minister, just to wrap up this particular clause, we also had comments from JMMB. They were of the view that BOJ should prepare its annual statement of accounts as per international financial reporting standards, by saying that we're following GAP as prescribed by the ICAJ. We would be then preparing our statements under IFRS. IFRS has been Jamaica's GAP since about 2002. The Jamaica Cooperative Credit Union League also offered a comment. They had observed that within clause 43 there was no timeline stated in relation to when the audited accounts should be prepared. But I think they failed to recognize that in the Principal Act, Section 44 already covers that. And in fact, the time period that they were recommending is exactly the time period that is in Section 44 of the Principal Act. And that's it for this particular clause.
All right, who is doing 21?
Thank you, Chair. Section 44(2)A at clause 21 of the bill seeks to amend Section 44 of the Act by adding a proposed new Section 2A, which requires the Governor to submit to Minister a report on the performance and main activities of the Board and committees of the Board. This is new. The proposed section also provides that the Minister shall table a copy of that report before the House of Representatives and Senate, and for the Governor to present the report to the House and answer questions in relation thereto. The current provisions speak to the submission by the bank to the Minister of the bank's annual report and audited financials, and as I've said, this is a new aspect of it. Section 45A.
In practice, the bank's annual report has been tabled in
practice.
Yeah, but the Governor answering questions, that's the part that's new.
Yes.
Yeah. So it's not so much the tabling.
The PBMA, it would have to be tabled here.
It's not the tabling that's new.
Tabling that's new. It's the
it would be coming before the Governor himself or herself, coming before a committee of Parliament or the whole.
No, the House.
We never determined, Chair.
No, the whole House.
The whole House, so like the Standing Finance Committee.
Standing Finance Committee.
Right.
No. Hold on a second, Chair. So you table to both the Senate and the House of Representatives.
Yes, but they come to the House of Representatives, not to the Senate.
You have to take the plunge if you want to get that.
You have to come, you know what I mean? have to go run a seat. If you want to come here, we shouldn't even make you sit in the same chair. We're going to have a new chamber for you. All right, 22.
Yes. 22, clause.
Forget 22. Maybe again it's a matter of wordsmithing, but I feel we can break up this long sentence here. 21, when it speaks, for example, to the Senate, we could full stop. And then says the governor shall present report to the House of Representatives, because you have a continuum of Senate and House, two chambers and so. So it's about drafting.
I mean, it could be a subsection 2B or whatever, but that could be.
I wasn't seeking to
but the question of the timeline as well. I mean, how long after it's been tabled?
Exactly, that's a point I saw.
How long after
it seems
should the governor come and present?
The governor could carry it around in his briefcase for the year.
I mean,
before forwarding it.
Within 90 days?
No, I think as soon as the minister gets it within 90 days, within 3 months after the end of each financial year. I think, and the minister, as soon as practicable thereafter, should cause it to be tabled.
As soon as practicable.
When does the governor come and report?
As soon as practicable after the receipt of the report, cause the report to be laid, and the governor shall present the report to the House of Representatives. All right. And so if you had a second subsection, you could say the governor shall present a report as soon as practically possible.
Or say within, as soon as practical, in any event within 90 days or something of it being tabled.
Of it being tabled.
Yeah, because when it's tabled, the time, he couldn't present before.
I'm telling you, we're moving steadily towards some changes that we're going to have to make. I think Parliament is meeting once a week and having.
Yeah, but what we need also, Minister, and you can make these changes right now, is provide some support for the committees. We have about half the size of these books to log back and forth to PAC every week, and hundreds of pages of reading. We have absolutely no support staff. You have PAC, you have this joint select committee, you have economy and production tomorrow, you have another joint select committee, and so for 3 days straight, I am sitting pretty much all day, and each of those committees require background reading and research. I spent a whole morning at Petrojam's pricing committee this morning trying to understand the formulas and the worksheets and the workbooks the workbook that they use there. So it is a lot of work. People have this idea that, you only sit one afternoon a week. Exactly. An MP doesn't even get one research assistant assigned to do parliamentary work. And I really think that is, certainly there should be if somebody isn't sitting on any committees, that's one thing. But when you're servicing 4 or 5 committees, it's really unreasonable not to even give a research assistant to help you properly prepare to treat with the matters of the committee.
Outside of that, Chair, while Charity, let me use the opportunity. We're putting in these bills that are calling for a greater level of support. But even if you look at the structure, the operational structure of the Parliament itself, the Parliament need more staff.
You're preaching to the converted. I think the opportunity, and we're way outside of the scope of the joint select, but I think the opportunity of the Parliament is not well resourced in terms of staff, not well resourced in terms of space, and otherwise. And the opportunity for the upgrade that is in the pipeline might it presents opportunity to not only upgrade the space shortfalls, the hard infrastructure, but the soft infrastructure as well. Yeah. And I think we shouldn't miss that opportunity.
Chairman, just for the record, I was watching a program last night in which Amy Klobuchar, an elected representative in the United States system, I want to make that so I don't want to equate Senate here and Senate there, but she is given 25 members of staff. for her office alone. And I mean, there have been a week ago, I had four meetings in 1 week, much less the members of parliament. And some that we have to look at, because the criticism often come, all parliament not meeting enough, all the parliamentarians not doing enough. And these are criticisms of people who have loud mouths, but not enough knowledge of what is happening.
Yeah.
And I think it's important to say so.
Based on inadequate information.
I'm with you on that. But just coming back to this, if we have a second subsection, the governor shall present the report to the House of Representatives as soon as practicable, shall present to the House as soon as practicable thereafter.
Senate, end at the word Senate.
Yeah.
And then add a 2B that would say within 30 days or...
No, man, not 30. No way.
I was thinking 90.
No.
Chair, could I just ask a question in this regard? So tell me how this works. The governor is going to be called at such appropriate time. Can the governor say, okay, I need to come in 30 days? So in terms of wording, as it is here now, the governor is available and makes himself available or herself available to attend. So when you say the governor shall present in 30 days, 60 days, 90 days, how does that work?
Really, right
Parliament
now,
as busy, how does that work?
Really, right now, it says as may be required. So it would be, in a sense, Parliament that would summon the governor to come. Yeah. But we're saying, we shouldn't leave this at large.
No, I don't think we can put a time. I mean, it is.
Yeah, you're dealing with the annual report, though, Mr. Chairman. Yes. So if you let too much passage of time, it won't be relevant.
No, but this is the Bank of Jamaica Act. How do we compel the Parliament to invite the governor in the Bank of Jamaica Act? That's not in the Bank of Jamaica Act.
No.
Well,
so...
It's a law made by Parliament, and Parliament's law says
Parliament
that
have to follow its laws.
Facilitate the governor presenting a report. I don't see a problem with that.
Again, Chairman. Sorry, go ahead, Karen.
No, I'm saying it's the wording because I don't want us to write something and then it's just impossible.
I don't want to deal with the wording. I believe we know what we want here. We want promptness. And so what we should do is to look at 2A and redraft to fit that. And in so doing, take into account that the governor has to, through the minister, present the fiscal policy paper, which itself is subject to...
Not the governor. The governor is not involved in the fiscal policy.
Well, the fiscal policy paper will come from her. Yeah. So that's an issue that comes up that the Parliament will want to look at, usually at budget time. Yeah. But that budget ends at March. Then 3 months after March, you're down to July. You're in recess. Practically, you're in recess after the sectoral debate. You're in July, you're in recess. You get back in September, another fiscal policy paper is also due. Then just want to look at the
you want it to be prompt.
Logistics.
You want it to be prompt. I mean, if it's annual...
all I'm saying, look at the logistics that will lead us to promptness, but take into account the practicality of the Parliament's operation.
But Chair, Chair, I don't know, unless I missed a part of the discussion. The section says that within 3 months, the governor shall present to the minister, and then the minister, as soon as practicable, shall lay the receipt at the house. Is the discussion that we should put in a time frame for the minister?
No, we want the governor to appear before the house.
But what? Yeah, but couldn't the governor be called upon? So I don't know if we have to include that.
The mechanisms, how would you be called upon?
Yeah, that's what we're saying.
It'd have to be a committee that does
Yeah,
that.
but it would be a committee.
No, that's not the point of this. The point of this is to enable him to come and address the whole house.
No, but
That's what we have been told.
Yeah, but again, well, let me say, Chair, I believe we already have a mechanism in place where once the report is tabled, then the appropriate committee can call up.
Which committee?
Whether it be the PAC or
No, not for the government, not for this. This is national.
Yeah.
So we want it. We want all members of Parliament to be able to ask questions.
So to be clear, we're envisioning that the governor will come before the Standing Finance Committee of the House.
Essentially.
Yeah, essentially. We're not calling it that.
Yeah. All right, but I'm going to take Senator Brown's.
But Chair, why not a committee of the House?
No, because this is something that affects everybody, monetary policy and so forth. And the idea is that we want to have all members of Parliament have the opportunity to ask questions of the governor in this scheme.
Including the member with responsibility for the people at Barbary Hall who may have some concerns.
Oh yes, the member who has responsibility for the people at Barbary Hall does believe also in the systems of governance that we have in place. In other words, committees act on behalf of the Parliament.
Yeah, but so in this, we want it to be the entire House.
I mean, the PAC deals with Auditor General reports. The PAAC chooses what it wants to deal with across the public sector. This is really focusing on inflation targeting, monetary policy, and bank supervision, what they've been up to. So the idea, I don't know which committee would be the right one if you're going to limit it to a committee. I may not be on that committee. You may not be on that committee. You may want to be part of this discussion.
This is something that everybody's going to want to participate in. Right? Or at least hear, even if you're not talking, but at least be a part of the discussion.
Mr. Chairman, I'm just wondering, is this an issue, though, that would be dealt with under standing orders?
The mechanism might be dealt with under standing orders.
Including even the timing?
You could amend the standing. We did it for the Integrity Commission Act. We can amend this. We can have a schedule here, making an amendment to the standing orders pursuant to this section to say that the House shall convene or invite the governor to issue his report and to field questions thereon.
Where I think the appropriate change would be in terms of timing. All right, can we understand what we want to achieve?
I would just like to raise, though, so the Integrity Commission Act did do, in that, at the time would have been a bill, did an amendment to the standing orders. There is a view, there was a view from Parliament, well, from that the standing orders, it was not an appropriate way to amend the standing orders. That was a view coming from
so they say Parliament can't amend the standing.
Well, I don't hold the view because I think it's Parliament and Parliament can decide.
I disagree
but apparently,
with that view.
Well, just saying though that there is a procedure for amendment to standing orders, so doing it in the bill the view was that doing it in the bill was not in keeping with the procedure to amend the standing order. So I'm just putting it there as well. But the bigger issue is I think this is something that would be better done through standing orders.
I agree, standing orders is the place.
Does the SG and the AG department feel that the way it was done in integrity legislation unlawful?
No, that's not the view of the AG's chambers.
Cool, thank you.
So we were being innovative when we included that. We were abandoning the traditional, which may not have served us ideally, and introduced an innovation.
The Standing Orders Committee, I mean, if you were going to wait on them to amend the standing orders, then this won't happen for years. So it should be done by this mechanism. And I think the Chamber should issue an opinion and correct their flawed thinking on the matter. I really do, because we're going to do it again. We're going to do it again.
Unless we find a better way. All right. First of all, the first thing, it should be through the standing orders, I believe. I would be advised as to whether or not we can do it in the bill. If the view is that we can, then we go ahead. Huh? It's a convenient time, 528. Unless, can you just look at 22 and see if we have any issues with 22? It's short. No, 22 is the end of the page. So let's look at 22. It's the last
Could
four
I
lines of the page.
talk fast on this?
Just talk fast on it.
Okay, talk fast. Noting comments made by the committee earlier in relation to the inclusion of the contents of the regulations in the form of a schedule, Section 45A as proposed would need to be amended, and very simple amendment. If this is decided, it is suggested for consideration that the provision reads, the minister may, in consultation with the board, by order amend Schedule 2 of this Act, subject to affirmative resolution, subject to wording. Would that capture, because it captures the aspect that the board can have some input. It's in consultation. The minister would do it by order, and it would be by affirmative resolution. Those ingredients. That's the proposal.
Yeah. Does that meet everybody's satisfaction?
Subject to the wording.
Subject to the wording?
Aye.
Existing wording suggests that the board determines their own governance arrangements. And that's a bit incestuous and self-serving.
It speaks to recommendation of the board. Well, now we're talking about consultation. If you go back to the document, recommendation is really not lifting it to approval. So even in the current wording, it spoke to the minister overriding, for want of a better word.
Acting on the recommendation of the board.
Well, acting on is really strong.
If they don't make a recommendation,
true.
they know
Acting on is strong.
Suppose it's in consultation with.
But in any event, Chair, the wording I'm proposing now for consideration speaks to minister may in consultation with the board, and everybody agrees that consultation is really not more than consulting and not as high as recommendation, and certainly not advice. So if that general principle is agreed, then those that draft could perhaps.
Out of interest, what kind of provisions might be in these regulations?
Now remember, the regulations contemplated here was the same governance regulations we're talking about. So we don't have, right, and this particular one.
Those PBMA are around external Auditor General's ability to require an additional audit, and it's not so much about board governance.
What I understand, Ms. Chinqui Akin to be saying is that this regime would include doing regulations, for example, on those additional requirements which we wanted brought over from.
Absolutely. This provision was originally the regulations, which are the governance regulations, which incorporated the PBMA. So the schedule I'm speaking of is the same schedule that's been discussed, which is the PBMA and other governance provisions, which will come as a schedule. The only other point I wanted to mention quickly, and I just haven't had a chance to wrap my head around it fully, is that I've proposed here a Schedule 2, but we already have a schedule under the Act, so I want to discuss with OPC whether we'll probably merge them. The current schedule to the Bank of Jamaica Act address governance matters like board, matters relating to the board. So it could be that when I speak with OPC, we'll come back with a recommendation, Chair, that the two go together instead of having two schedules.
But I just want to know, the PBMA provisions that I was referring to in appendix are not the same as board governance issues. Yeah, true is that board governance issues would be around things like committees of the board. I don't know what else. That's why I'm asking, what would be the content of these regulations, really?
Okay.
Yeah.
So the proposed regulations which are being crafted include the PBMA provisions and also some board-related type of governance matters like the board remit, some aspects to do with board remit, and other things. So I think maybe when it's put together finally, and Chair, so maybe governance speaks very broadly in terms of not only board governance as in how the board operates, but governance in a wider sense, and it incorporates the PBMA provisions. I hope that was quick enough.
Yeah. Okay. We're at 3 minutes after 5:30. Thank you very much, committee members. Then I don't think is there any other business? Okay. The date of the next meeting is June 13th, which is a Thursday, I believe, and it's at 10 o'clock. Thank you all very much.
No, I thought 2 o'clock.
2 o'clock, sorry,
What's
2
it?
o'clock.
I don't like that 2, but
2
2
o'clock.
o'clock is okay, yeah. It's 2 o'clock on the Thursday. On the Thursday.
Come on, in the time that we are now, with the events of yesterday, surely you can say 2 o'clock. On June 13th. Yes. So can we have a motion for adjournment, please? So moved. Member Bunting, seconded by Senator Gale. All those in favor? Thank you all very much.
It's a new day. Our responsibility to protect our children from harmful TV and radio content.
A and X are no-nos. PG is maybe. G is good to go.
Protect your children and report offensive broadcast content. A message from the Broadcasting Commission.
Make it a new day, yeah.
The corrupt are getting away too often. Help catch them now. Jamaicans must call 1-800-CORRUPT.
Yes!
Enforce the law. One law for all. If convicted and found guilty, lock them up. It's our money that's being wasted. Lock them up. Stop